one was anyway.
I'd have to look back, and I don't have time to do it.
We ain't gonna do it right now, but just don't forget that we don't have in all likelihood it'll show up somewhere before we're through, but if it doesn't, let's make sure the record's complete and that we get a 71 in the file. Anything else before we bring the jury in?
Your Honor, before we move forward, we anticipate asking the court to allow the introduction of the lab report based on the testimony of Ryan Baker, and what it would include. It's a 13-page report, Your Honor. What we would request would be the entire report under the current case law, and if the court reviews the report and finds that portions of the report are not to be admitted, then we would at least ask that the working parts of the report as to what would normally be in a crime lab report.
I understand what you asked me. Tell me what you think the law is anyway.
I think the law is that under 803.6 that we're able to introduce the report that the confrontation clause does not apply and it's admissible under the circumstances.
I know Mississippi Supreme Court is somewhere has, I believe, said that this particular issue comes up in about 70% of the cases that are tried of violence in this state. So the Supreme Court ought to have made a pronouncement on it. Go ahead and tell me what you think the law is, Mr. Dagnall.
Judge, I believe that the controlling law and the direction is made clear in Lentz v. State. That's 604 Southern 2nd 243. Judge, in Lentz v. State, what happened there is that a lab report was created by a lab in Alabama, and it was sent to a local lab in Mississippi, and the custodian of the record of the Mississippi lab was the individual that was proposed to testify. The state objected to that because the individual testifying was not the one that created the lab. The state is the one that argued hearsay in that. However, that was the court there overturned, ruled that it was error for the trial court to not allow that the record to be testified by the local agency. It was error because
when you say the local agency, do you mean a local police department or a local crime lab? Was there a crime lab person?
Judge, it was a local crime lab, but that's not what the distinction was made by the court. It was the fact that it was the local custodian of the records. After the record is provided, the only thing that has to be after the record is provided as an 803.6 record normally kept in ordinary cause of business. Only thing left has to be authenticated, and that can be done by the custodian of the records or any other qualified witness. That can be the individual that is the custodian of the records by the one taking it in to add to that agency's record, or any other qualified witness. Certainly Ryan Baker would qualify for that as the custodian of the entire record and report in this case, and as a qualified individual by being the one most familiar with it. He created the entire timeline of this. He knows what the contents of these records are. So, Judge, the fact is that under 803.6, this is not a hearsay document. That's clear. Moving past that, only other determination that has to be made.
It's not a hearsay document or exception? Or
it's an exception okay. because it's a clear 803.6 document. So then, like I said, the only other thing we have to move to then is whether it can be authenticated through either the custodian of records or another qualified person. That's clearly Ryan Baker. And then, Judge, in addition to that, under 803.24, if there's other equivalent circumstantial guarantees of trustworthiness to those that exist in other hearsay exceptions, then the condition precedent to admissibility is satisfied by the evidence to support a finding that the matter in question is what it is purported to be.
In other words, judge can just say, yeah, I think it's good enough.
That's just an extra.
I understand your argument. I'll give the state an opportunity to respond. I don't know if I'll necessarily make a ruling this time with the jury with the jury waiting back there. But before the conclusion of the state's case in chief, I'll give you an opportunity. I will make a ruling as to the admissibility of that document. Has it been marked for ID at this time? Somebody remind me what number that is before the state, at the time state, on or before the time court, state rest, and I'll give you a decision on it. And it may be that I can give you one right now, but I want to look at it.
Judge.
All right, go ahead and make the state's argument. Tell the jury we're working, but we're going to be with them just a second. Okay, you already have, thank you. Go ahead.
Yes, Your Honor. The state, I believe we sent the Odom case, which is actually a more recent case. It is 383 Southern 3rd 322, which in that case, they attempted to introduce the defense wanted to introduce a crime lab report through an officer. And it was in fact ruled to be hearsay because the officer was not considered even though the officer was in fact the officer over the case, the lab contents were hearsay. It says documents and reports of this nature are classified as hearsay. Similarly, in a case where an employee of a crime lab was not called as a sponsoring witness, it was error to allow DNA reports to be admitted into evidence. And it's citing to a Mississippi 2012 case.
Let me do this. Brooke, my staff attorney, she's sick. She and is not here today. If y'all, I would ask her to pull those cases for her, but she's not here. If y'all would both sides pull me any cases that you want me to consider, I'll read those cases during our next break. Okay?
Yes, Your Honor.
All right. All right. What else we got to take care of before we bring the jury in?
No, I just wanted to make sure that, we asked to speed things up to get Detective Baker to block those.
Yes. Let's find out. You get that done, Mr. Baker?
Yes, Your Honor.
Are they consistent with one?
If you'll let me see it again, I'll pull it up on mine.
Y'all see where we stand on our homework assignments anyway.
Okay.
Your Honor, I would like to also make just another point for the record as to the crime lab report. From the testimony of Detective Baker yesterday, he stated he wasn't familiar with all of the contents of the report. To assign him as the custodian of records when he stated that he thought it said something else it didn't say, he wasn't familiar with it. He doesn't know if it was made at or near the time. He can't meet the requirements of 8036.
I'll give me your cases and I'll review them in the break. Why don't y'all confer for a minute and see if we can have everything ready to go. What you looking for? I got you. I tried to sort them out a little bit there anyway. 106 is I think the last one. Go for the back anyway. I think you might be looking at the last document.
You want to set things up there? We need to, that was the original.
I don't know if we got enough coffee cups or not now. Yeah. All right. Y'all be getting at the other court meeting. Right. Another month or so, we'd have it organized.
You ready?
No, you go ahead, let's get that organized while you're doing it. Vicky, you grab me my pen off the desk back there. Thank you, sir. Mr. Horan, you and Mr. Baker on the same page?
Yes.
All right. We're trying to organize these exhibits a little bit to make it easier when y'all start looking for things. We won't spend quite as much time shuffling. All right, everybody ready now? Mr. Baker, if you want to, go ahead and retake the stand. Show the jury in, Lynn. Good morning. Hope y'all had a good evening and ready to come back to work. So if you ever have any problem with court instructions, let us know. More. We're not starting exactly at 8:30 this morning, but we spent a little time organizing, so maybe we'll spend a little less time shuffling papers today. Okay? When we concluded yesterday, Mr. Baker was on cross-examination. Mr. Baker, you remain under the same oath, and you may continue your cross-examination.
Thank you, Your Honor. Mr. Baker, Detective Baker, we stopped yesterday in the examination pertaining to the certain ping locations of Jay Lee's phone, and I asked you to chart out due to the fact that you can do that based on your training, and you had an opportunity to do that.
I did.
All right. And I believe this is exhibit 106. You look at it, please. Did you have an opportunity to compare your latitude and longitude coordinates with that Exhibit 106 and determine whether or not it's accurate?
Yes, I did type in the latitude, longitude coordinates of those last 10 pings that you asked me to do. And for the most part, they look fairly accurate. Our maps looked a little different, mine, but with a point or two.
I don't make sure I'm on the same page as everybody else. I want to make sure I was on the right page. Go ahead.
Those coordinates plotted on that exhibit 106 are consistent with the plottings of the coordinates that you compared when you plotted them yourself, correct?
Yes, just putting the Latin long from the CDR is not giving into account of the radius and the range of measurements like CDRs are supposed to be done.
I move for introduction.
Any objection? I hear no objection, so I'm gonna say, I'll say there is none anyway. All right, 106 will be admitted.
So that pertains to, those plotting points pertain to the lat long of the ping locations based on, consistent with the other ping locations that you testified about earlier in this trial yesterday, correct?
Which ping locations are you talking
Any
about?
ping location.
No, they're not all consistent with all of the ping locations. No, the phone locations are different.
I'm asking about the ping locations. You charted it in the same manner that you charted the previous ping locations that you introduced in the evidence, right?
Yes.
Okay, that was my question. I want to ask you a little bit about a couple of things. You were familiar with the fact that I believe on this exhibit 106 has the Lafayette Place on here, correct?
I have to look at it again.
I believe it does. Lafayette Place located on that?
Do not see it.
Okay. So can you tell me whether or not you were able to locate ping locations of Jalen's phone at close proximity to Lafayette Place during the course of your investigation?
Yes, as I last has told you, that those are just the lat longs that AT&T gave. Now, and that's just a guess of AT&T. You've got to take the radius and everything into effect, the sector tower, the side of the sector, so forth. You've got to take all that into effect. So that's just the range. You've got to take the range, be able to plot all that out, not just the lat long that AT&T gives you.
My question was, did you plat the latitude and longitude of the ping location from the towers at Lafayette Place and indicate if in that area that his phone was located in that area, yes or no?
Yes.
Okay, thank you. And you also, during the course of your investigation, found yourself reviewing certain search warrants pertaining to evidence there at Lafayette Place, like the lock audit. Did you review the lock audit search warrant information?
I was told about it, yeah.
You haven't seen it?
Your Honor, may we approach?
You may. Okay?
All right, thank you. Mayor Pro Tem.
You may-
Look at that document. Tell me, recognize the contents of that document.
Only for identification.
94.
Yes, sir.
You familiar with the contents of that document?
I've seen it before, yes.
And it appears to be what?
It appears to be the return for the log audit from that search warrant.
Isn't it the fact that you've got ping location data in a general vicinity consistent with the information on this lockout as far as apartment in the area of Jimmie Herrington's apartment, correct?
Yes, but during our investigation, the apartment complex said that that was not correct, that this was not working correctly.
I'm asking whether or not that lock audit y'all received in return, as return of your investigation, and the ping location general area is consistent with the location where this lock audit was retrieved, Mr. Harrington's apartment, correct?
Where it was retrieved, yes, with Lafayette Place.
I'm
Yes.
just introductions and stuff.
Objection, Your Honor, to hearsay, and also I haven't seen the document.
Let her look at it. I'm not sure if I understand what we're talking about.
Your Honor, my objection remains that, one, it's hearsay, two, it was corrupted, it was not accurate information, so.
Your Honor, just
It also doesn't have the defendant's name on it. It says Stephen Union.
I'll be honest with you, I haven't learned enough about what you're talking about to make a
Your Honor,
decision as to what it is. And you
Your Honor.
won't come to tell me what it is, I will. But, I don't know what you're talking about.
Your Honor, we just testified, this was the lock audit return from the apartment. Mr. Baker, you're familiar with the fact that on July the 22nd, that y'all executed a search warrant for not only Mr. Harrington's apartment, but also the resident key lock information on his apartment, correct?
Yes, sir.
What that reflects is the resident key information to the entry and the exit of his apartment as registered at the Lafayette Place, correct?
Yes, sir.
Consistent with my prior questioning, ping locations pertaining to Mr. Lee's phone, we talked about earlier, what you answered was that there were ping location areas consistent with this apartment rented by Mr. Harrington at the Lafayette Place. You said that was correct, right?
If I understand that long question correctly, Lafayette Place falls into some of the ping areas, yes.
This is the apartment, lock audit, resident key lock audit, Mr. Harrington's apartment that y'all executed the same day that y'all executed the search warrant on his residence, correct?
Yes, as I answered before, yes, that's
And
correct.
that is the return and the contents of that return on that resident key lock audit, correct?
Yes, that's it, yes, correct.
For introductions this time, y'all.
Your Honor, same objection as to hearsay.
I'm gonna let you question him on it, but, I I'll let you question me anything about it this time, but, that document, I'm not gonna introduce it to the evidence. I'll, hear you.
You can allow an introduction.
I'm not allowed an introduction at this time. If y'all need me to send a jury out to argue over it, I'll let you, okay? Y'all, bring your tennis shoes. Have we got some certificate of authenticity or anything like that with it?
Your Honor, just return to the search warrant that they provided me that they executed on it, Your Honor. It's in their report. They represented that this was a return on the search warrant. The fact that it's in their report that they got it, he's reviewed it.
I'll listen to the state.
Yeah, yes, Your Honor.
It's no different than.
Hang on, let Mr. Holan finish first.
It's no different than the previous search warrants where we provided information to the investigators, return on the search warrant, they executed the search warrant, this was the return they got from the federal.
I will ask this, how is it, I'm gonna ask the state this, how is this any different from the return of a search warrant of a, cell phone record, Snapchat, Facebook, Instagram? How is this return of search warrant any different?
Yes, Your Honor, those came with certificates of authenticity that stated that they were authentic and this accurately represented and was made at the time of close in time to the practice and was a regularly conducted business record. This did not come with that. In fact, if Your Honor looks at it, it says it doesn't even have the defendant's name on it. They're representing that it is the defendant's apartment, but it doesn't even have the defendant's name. The problem with hearsay, Your Honor, is that when you have a testimonial document, you have to be able to question it. Within that document, as Detective Baker testified, he was told this was corrupted and not accurate. And again, it doesn't say Herrington's apartment.
Let me look at it, okay? Or you can talk now, I'll look at it.
Your Honor, let me get part of the report. Wow. Judge, this is the exhibit as offered.
You know, they could have gotten someone from the apartment.
Hang on a second. I'm gonna give you your chance.
Now, the last page indicates the lock audit report identifies the apartment that's already been used in evidence. The dates and times relevant to thing locations they've already testified to. That's what's been provided in discovery. Turn on the search warrant. There's nothing in either report indicating that it's not valid.
Let me just read a little bit.
Your Honor.
Hang on, I promise I'm gonna get to you, but this is my first experience at looking at a lock audit. I don't exactly know what they are. I'm not sure what a lock audit's supposed to do, but I see dates and times. I don't see any. I believe, if I understand it correctly, this is one of those deals where you have one entrance door, common kitchen and living room area, and each individual has their same apartment, same. Tell me what we got going on.
Look at the top of the last page, it's lock audit report for the apartment in the photograph, identified as Herrington's whole apartment. When he walks in the door, uses his key, it registers according to that lock audit report.
Sweet, you're talking about, this is the lock of the main door, for
Yes,
lack of a better term. That's what I was,
They executed the warrant, at the same time they executed the warrant on the apartment. Exactly the same time, same day. It testified about yesterday to Mike Burns and argued by our counsel for the state, Mr. Creekmore, that the next witness was a witness that could authenticate these documents or verify that they were received and used in course of the investigation.
I'm gonna do this. I'm gonna not allow the admission of this document. I don't see any. It lacks indicative reliability in it. Apparently, contrary to testimony, it starts everywhere from. We've got.
That's the return for the dates they requested, Your Honor.
Well, let's see that you got.
Look at the entire
Yes,
document.
I'm looking at it. I'm looking at July the 8th here anyway, and all I see is Joseph Yoon. All these documents refer to Joseph Yoon. From this document, I can't tell that the defendant ever lived at this apartment.
Your Honor, they put in evidence that they got a search warrant on the day of. Joseph Goon is an individual apparently may have rented the apartment 5 years ago. That doesn't matter. They testified in this case that they executed a search warrant for lock audit of this apartment on this day that represented the apartment of Timothy Herrington.
Okay.
At the same time, they executed a search warrant on the actual apartment lock audit, the door that's in and out of his apartment. Testified this was what they got back. He's reviewed it, and he says no report of that. I was going to cross him on it. Absolutely no report that it wasn't reliable. They acted on it and they used it as part of their investigation. I don't have to, under any circumstances, provide a certificate of authenticity. They took it into the report. He can testify it's unreliable if he wants to. Do all he wants to, just like the burglar. He introduced the burglar just 5 days ago. Okay. The burglar report was introduced, a return, without a certificate of authenticity, because he testified, Mr. Douglas testified, they reviewed that document, had those documents that were returned to them pursuant to a search warrant. They deemed them unreliable. That's beside the point, Your Honor. Execute the search warrant. They can point out whatever they want to on it. But at this point in time, it relates back to exactly the same search warrant involving the apartment. It's the door on the outside, the resident key. And they asked for it, and they got it. For this date in question, 7/8/2022. It has they asked for the entire lock audit. I don't know why they did that. That's what got returned to them. All the information on the resident key lock audit. They got it in return, just like the search warrant.
All right. I'm going to listen to you now.
Your Honor, the difference between that and the burglar is that the burglar, we know for a fact, came from downloaded the Burla themselves and sent it to Soto County to be read and got a report. This they got from the apartment, and now he wants us to just assume it's the same one. Yes, he told the apartment, but he's like the opposing counsel said, Stephen Yoon, maybe it's someone that lived there 5 years ago. So the apartment keeps bad records. So now we know the apartment keeps bad records. We don't know if they keep correct records.
I'm going to find it lacks sufficient indicia of reliability to be admitted this time. I'll let you cross-examine on it, but I'm not going to send it to the jury.
Go and Doug for a moment.
I won't prevent you from calling the witness to authenticate, explain what record it is and things. I think it lacks insufficient indicia of reliability.
Okay, I'm ready.
All right. Everybody good? Show the jury back in then. You may.
Detective Baker, you identified incident 94. When you identified that as returned on the lock audit, resident lock audit key.
Let me talk to y'all 1 second. That's but I show 94 is already admitted.
Detective Baker, I want you to look at the lock audit report that came back. Just tell me whether or not that appears to be the lock audit report that was returned as a result of the search warrant done, I believe, on the 22nd day of July 2022.
Yes, it appears to be screenshots that they had returned, yes.
And that's the content of the return of the search warrant. I think Mike Burks previously testified to that he did, correct?
Yes, this is what they gave us as a result of the search warrant, yes.
Thank you. Do you have any reports in your file? Are you aware of any reports that have been provided to the DA's office indicating that the contents of this lock audit report are not accurate?
I don't know of any reports. I don't recall. I'd have to look through all of them again, but I do recall us talking about it, and that's why we didn't give much weight in our investigation to it, because it was a new apartment complex. They had just changed ownerships, and obviously you see screenshots. They didn't even know how to download it and give it to us in an official capacity, so we didn't give it much weight because we didn't know that even to them they said they didn't think it was correct.
Do you have any reports? My question was, do you have any reports in your file that you can use for the benefit of this jury? Just asking you, Detective Baker. Any reports indicating that the return on this indictment that indicates the residency lock audit, either from the individuals reported to y'all that it was inaccurate, or that you determined through your investigation that they were inaccurate? Do you have any reports indicating that in your file? Yes or no?
No, not that I'm aware.
So again, for the first time today, you're testifying those records are inaccurate.
First time I'm testifying, what do you mean?
Today, first time we're hearing since July the 25th is when the return was done. Today's testimony is the first time that we're hearing that those lock audit reports, of resident key lock audit reports, are inaccurate, correct?
I'm just telling you that that's what our investigation revealed, and that's the way we took the investigation.
So you're telling this jury that you have a report when y'all got together, and y'all got together about the search warrant on the resident that day, did you not? When you did his apartment, y'all got together afterwards and talked about what y'all had retrieved as evidence, right?
Objection, Your Honor. I thought this was to do with pings.
What's that
I
now?
thought this was supposed to be to do with the ping data.
Open the door on this, Your Honor.
No, I'm tight to ping, just tight to pings or move on.
He was unresponsive to my question. He's one who brought up about the inaccuracy.
At this point, you're not tying anything to pings. You can tie to pings, tight to move on if you can't move on.
You don't have anything, I asked one question about the ping, Your Honor.
Okay?
You don't have anything in any report indicating that your ping locations were inconsistent with activity that you found going on in the vicinity of the apartment or at the apartment, do you?
I'm sorry, I lost you. Can you rephrase the question?
When you got the resident key information, that lined up with, did it not, your information about your exigent ping location pertaining to Jay Lee's phone, right, correct? At that time.
I know nothing about the accuracy of that, so I can't say whether it lines up or not.
No further questions.
All right? You may redirect. Good morning. Hey, just while I'm thinking about it, Brooke has arrived, hopefully feeling better. Those case laws that y'all re-referenced earlier, if y'all would let her take a look at those, okay? All right, go ahead. You may proceed.
Detective Baker, yesterday on cross-examination, you were asked about how you all, as an OPD, got Jay Lee's toothbrush from his apartment and more than 14 days after July 8th, and you searched Timothy Herrington's apartment more than 14 days after, and why that didn't corrupt the DNA in Jay Lee's toothbrush. Explain to me the difference.
Yeah, so the difference is that Jay Lee's apartment had been preserved. Jay Lee's roommates had already moved out, so there was nobody there. Jay Lee hadn't come back, and so it was preserved. There had been no contamination because nobody was in and out, with a few law enforcement who are trained to not contaminate the scene as little as possible. And so the difference between Herrington's apartment is he'd been in and out for 14 days, in and out roughly, so he'd been in and out, unlike Jay Lee's apartment. So Tim Herrington's apartment was more contaminated, and Jay Lee's appointment was preserved.
You also were asked about the searches you all did in 2024. Why are you all, as in the OPD, searching in regards to this case in 2024?
So we've continued to look at this over the last 2 years, continued to analyze phone data, location data, all these areas of possibility where Jay Lee's body could be. And so just because we did a search and we didn't do a report because we found nothing, I mentioned SOP yesterday, our standard operating procedure doesn't require us to write a report just if there's nothing there to report. And so from that day that we started the investigation until we find Jay Lee's body, I will be continuing to look for Jay Lee's body for that family, no matter what.
And finally, Detective Baker, based on your investigation, the text messages, the interviews, all this video, including your interview of Timothy Herrington, what did your investigation reveal happened to Jay Lee?
Question, Your Honor, what happened to him?
Rephrase your question anyway, narrow it down a little bit.
What did your investigation reveal happened on July 8th, 2022?
I'm still asking for narrative.
I'm gonna like to get a more specific question. All right.
I'll rephrase, Your Honor. Detective Baker, based on your investigation, what did your investigation reveal happened between Jay Lee and Timothy Herrington on July 8th, 2022, between the hours of 4:00 a.m. and 7:30 a.m.?
I'm gonna allow to ask that question.
All right, so let me tell you what happened during the time between.
Your Honor, you have to be present to answer that question.
Hang on. I'm gonna let him testify as to point to data that would support anything he's saying. You can't just say that. If he, I would prefer a more specific question. What did your investigation happen at 4?
Your Honor, I can ask it in order then.
That would be a more appropriate question.
Detective Baker, what did your investigation show that Jay Lee was doing at 4:00 a.m. with Timothy Herrington? Right, it's 4:00, yeah, 4:01 a.m.
So our investigation showed that Jay Lee had left his apartment and drove over to Tim Harrington's apartment to meet for a mutual sexual encounter. Then, after that sexual encounter, where there was a little disagreement over Jay Lee giving Timothy Harrington oral sex.
Yes, Your Honor. Yes, Your Honor, it is the defendant's interview. He stated that Jay Lee was upset when he left. That is in evidence.
Reference the testimony that reports that anyway. What's the basis of your knowledge?
Detective Baker, what is the basis of your knowledge that Jay Lee was upset?
Tim Harrington said that in his interview.
Was that also in the messages that Jay Lee sent to Tim Harrington after he left the apartment?
Yes.
Following being upset, leaving the apartment, Jay Lee, what did he do to Tim Herrington's social media accounts?
So after Jay Lee left that first encounter, he went back home and he blocked Tim Herrington on all known social media accounts.
And what did Jay Lee message Tim Herrington around the time he blocked him?
So on Instagram, Jay Lee sent Tim Herrington, "I just wanted to be able to say, I had you be on the down low. It was fun being your first guy. Now you're back to block."
And after that, immediately after that, did Tim Herrington contact Jay Lee again?
Yes. So that had Timothy Harrington then contacted Jay Lee on an anonymous Snapchat account.
And did Jay Lee know who was contacting him?
No, he did not.
And how do you know that?
Because he asked him, "Who the fuck is this?"
And then what did Tim Herrington do after being asked that question?
Then Tim Harrington called him 3 times via FaceTime, 3 times in a row. Jay Lee didn't answer, so Tim Harrington turned around and called him via Snapchat.
And was that call answered?
Yes, it was.
And then did Jay Lee say Tim's name, indicating that he knew who he was?
Don't lead your witness, rephrase your
Your Honor,
question.
defense counsel, when I ask a general question, he objects. When I ask,
Well, asking what was his response, on, this?
I will do that, Your Honor.
Don't, that's a little too leading. Rephrase your question.
Second Baker. So after Jay Lee blocked Tim Herrington was triggered to contact him on an anonymous Snapchat account. Following the contact, did Jay Lee ever identify who he was speaking to in the messages?
Yes, in the Snapchat messages, Jay Lee told Tim to said, "Have a good night, Tim."
And what did Tim Herrington, per the messages, then do to Jay Lee?
So then, but they're in the messages, Tim is asking him to come back, more than once. And so then Tim Herrington, or Jay Lee, agreed to come over back to his apartment after Tim Herrington agreed to give Jay Lee oral sex from the front.
And in your interview with Tim Herrington, did he say that was something that he did?
It's not something that he did often, no.
Did he say that he's never done that before?
Now, that is a leading question.
What did Tim Herrington say?
That's a better question.
Yes, Tim Herrington told us that he'd never given oral sex before.
And Tim Herrington, following promising to give Jay Lee a sexual favor he'd never done before, what did Jay Lee then agree to do?
Jay Lee told Tim Herrington that he was coming over.
And then after Jay Lee told him he was coming over, what did Tim Herrington do?
Tim Herrington didn't respond to any more messages on Snapchat. Instead, Tim Herrington goes to Google and searches how to strangle someone.
And when Jay Lee arrived at Tim Herrington's apartment, what did he text?
He texted Tim Herrington, "Open."
And the Snapchat GPS ping location tower data, did it show Jay Lee in the area of Tim Herrington's apartment at that time?
Yes, it did.
And did Jay Lee ever send another text again?
He did not.
Brief indulgence. No further questions, Your Honor.
May this witness be finally excused or need to return to the witness room?
We'll keep him under subpoena.
I'll sit down, keep him under subpoena. All right, off. Can't stand in the courtroom, don't discuss your testimony with any other witness. I assume these folks know how to get in touch with you. We're not gonna tie you to a witness room, but, be available if they recall you, and, don't discuss your testimony. Thanks for being here. Everybody good on the jury? Who would the, state call as next witness?
Chief McCutchen.
Call up Mr. McCutcheons. Ben, let me see. This gonna be your name. All right, this. You may have a seat right here in the witness chair, please.
Tell the jury who you are
I'm Sheldon McCutchen,
and what do you do.
the Chief of Police for the City of Oxford.
How long have you been the chief of police for the city of Oxford?
5 years.
Okay. Prior to being chief of police here in Oxford, what did you do?
I served as Major of Operations from 2014 to 2019, and then I worked criminal investigations prior to that, and then prior to that, a DUI officer, patrol.
All with Oxford Police Department?
Yes, sir.
Okay. What were your duties as major of operations?
Overseeing large events. I was involved with the criminal investigations division, patrol, just really anything that dealt with the personnel staff of our department.
All right. And if you could, tell us how you became aware of the missing person of Jay Lee.
I was at church, and I either received a call or a text message that the university was working a missing persons case, and that they were looking at some data that led them to believe there may have been some travel routes on Molly Bar Road in that area. So our patrol was going to check the area and just try to help them locate.
Would you make the decision about how your department was going to cooperate and assist UPD?
Yes, sir.
And what did you consider when you were informed by UPD about a university student being missing?
That we would do whatever they needed. We listened to them as far as what information they had, and then we just said, listen, wherever we can search, whatever we can do to help provide information, we'll do so.
All right. And as far as the resources that were used and the approach that OPD would in UPD, were you making those decisions?
Yes.
All right. Now, at some point, it goes from being a case being led by UPD to Oxford Police Department having jurisdiction.
Yes.
Can you tell the jury about that?
Yes. So it was on the 10th. We received a call that the university had been notified that the car was towed at Bandit Towing, which Bandit says, listen, we took it from Molly Bar Trails, and that's within the city limits. So we ran a priority at that point on the investigation.
If I could have this marked for ID.
Mr. Creekmore, you also have my notes. Thank you. Yes.
what's been marked for ID as Exhibit 107. Do you recognize that exhibit?
Yes, sir.
What is that?
These are our social media posts that we shared on Facebook and Twitter.
All right, Facebook, Twitter, anything that you shared on Facebook and Twitter, would it also go onto Instagram?
It would.
And if you could tell the jury about the social media notices that come from OPD, how does that work?
So anytime we're working a case, especially like a missing person, we want to get information out to the public. We want to share everything that we can possibly share. Our is this. There's 80 some odd police officers. If we're working 24 hours a day, can't see everything, so we won't buy in from our community. So we try to push that information out anytime that we can. We'll take that relevant information of what we know, share that with the community, and then as this investigation went on, we wanted to be very informative of what we were doing so that people, again, felt like they were connected to this case.
All right, and in that exhibit, does that accurately depict the social media posts that were shared by OPD?
Yes, sir.
All right, Your Honor, this time the state would ask it be received.
Any objections?
None, Your Honor.
He's gonna ask a question before it's submitted.
If you would look on page 1 of the exhibit 107, it's got looks like a turquoise or blue highlight. That wasn't part of the original post.
No, sir, those are my notes.
Okay, all right. But didn't have anything to do with the post that was sent out or shared by Oxford Police Department?
The blue highlight did not.
Okay.
I still don't have an objection, I just want to clarify that.
You do not?
I do not.
All right, go ahead.
All right, page 1, that first social media post, can you just tell when that occurred and what the content of that message was?
Yeah, so it's a post by the university, and then we shared that post as a missing person on July the 10th. So it's basically their post. We reposted, we reshared.
And then at that point, UPD had jurisdiction.
Yes, sir.
All right. Then on page 2, what is that?
Sir.
Describe the date
So
and the
page
time.
2, this is going to be July the 11th. So the night of July the 10th, we work with the university to decide this is going to be a joint investigation. So this post basically affirms that this is going to be a joint investigation between the University Police Department and the City of Oxford. And then we just shared, again, the relative information of what we knew at this time, and just to let the community know, hey, this is going to be something we work together on.
All right, and the next page.
This is July the 12th, and we're updating that Crime Stoppers is giving a reward, and then we're kind of just educating people on what we're doing. Again, same kind of similar format. It's a joint post together.
And the content is all about seeking what?
It's for locating information and to find Jay Lee.
Okay, and does it provide numbers for the public to call if they have a response?
Yes, sir. It shares, it's got our information on there, as well as our public information officer's email.
Okay, all right. The next post?
The next post is on July the 13th. This is a video of Mr. Lee sharing a story about his son and compelling the community to come forward and give information. This was a video that we shot with him speaking directly to our community.
All right, next.
This post was shared July the 14th, and again, it's information about Crime Stoppers, but also another $5,000 for information leading to information for Jay Lee. And again, it's a little bit of an update of what we're doing and the information that we have on the new Crime Stoppers information.
So July 10th, July 11th, 12th, 13th, 14th. Next.
The next post we made was July the 19th. Again, it's same format, another update for the community.
Okay. Now, were there any other on Facebook, Instagram, Twitter?
I don't believe so. I believe those were specifically involving this case.
All right, the remainder of the pages in that exhibit, are they the duplicates, for lack of a better word, that you would have shared on other media platforms?
Yes, sir. It's the same thing, but we just wanted to show what it looked like on Twitter. And I don't think we put Instagram in here. It's all the same. It just showed that each platform got the same content.
All right. Now, we've heard testimony about Khalid Fears responding based on that request for information on those posts that were sent out on Facebook, Twitter, Instagram, correct?
Yes, sir.
Do you recall what day that was that you got that tip from Khalid Fears?
I believe that was on the 10th, but I feel like that came from the university.
Okay, 10th or 11th?
Yes, sir.
All right. Did you receive any other tips?
We received a lot.
All right. If you could describe in general the amount of tips and what your call was in.
Yeah, so we knew going into this that we probably would get a lot of information. And so we set up a tip line and we took every tip and took it in and then sought it out. We chased every lead that we could. The tips were very important. And with any case, you get a lot of information. And we took everything with the information that we had, and then we chased that lead down until we could move on to the next.
All right. Was there any way to evaluate or assess the material value of a tip as it first came in?
In a situation where you've got a young person missing, you don't triage it, do you believe it? You take it for what it is and you go after it. We received tips from other states and we contacted law enforcement down. We didn't take it as I don't know if I can verify it. We went after every piece of information they gave us.
All right. And what was the response when the Khalid Fears called and gave information?
He was interviewed. We went and met with him.
All right. Now, at this point, at this stage of the investigation, when it went from UPD to OPD jurisdiction, can you describe what type of resources that you authorized to come to bear on the investigation at this point?
Everything we could get our hands on. All of our local law enforcement worked on this. We connected with state partners, federal partners, anybody that we could utilize that had a skill set, we brought them into this.
All right. And at the same time, were you aware of investigators gaining access to Jay Lee's social media accounts and
Yes, sir.
through UPD's efforts?
Yes, sir.
All right. Were you able to get people that he would have been friends with or had contact with in and around that time?
We did, yes, sir.
All right, so you've got that information, you've got the tips. Can you evaluate all of that information, just in general, the people that had contact with Jay Lee, the names that you would have gotten from that information, as well as the tips? Let me finish the question. As well as the tips that came in comparison to the information that you found on Tim Herrington.
The information
Hold
we
on
got.
1 second.
I object to the form of that question.
I hate to ask you to repeat all of that anyway.
I can't.
I think I can answer.
I'm gonna allow him to ask the question anyway.
All right.
Can we kind of first compound first of all?
That's, let's break it up into little pieces.
What I'm asking, Chief McCutchen, is to evaluate the names that were revealed as persons of interest, either from the social media tips that came in and the information that you found about friends and contacts with Jay Lee, compared to the other information that you got implicating Tim Herrington? It's not a narrative. It's a comparison of the quality of information on all the people that were persons of interest compared to Tim Herrington.
I'm gonna sustain the objection. I'm gonna let you break it up into two different questions anyway. Comparing the quality, talk about the quality of the one set of evidence and quality of the other set of evidence, but not comparing the two anyway, if that makes any sense.
All right. Did you keep a running list of persons of interest?
Yes, sir.
All right. You did personally?
Yes, sir.
All right. Where did you get that information?
From our investigators.
All right. And you've already testified that you tried to track down every tip that came in.
Yes, sir.
All right. Did you do that?
We did.
All right. On each one of those persons of interest, were you ever to develop anything connecting them to Jay Lee, other than in relation to the morning of July the 8th, 2022?
We found no information of any of the leads that we tracked down of those persons of interest that gave any evidentiary value during the time of July 8th. And that's the way we were able to clear other people of interest.
All right. Now, you got a tip from Khalid Fears about Tim Herrington. What other evidence did you get after that point that would implicate Tim Herrington within that time period?
We had a volume of information that pointed to Tim Herrington. I think when we received,
We've hashed over all the evidence that CP had. What are we trying to accomplish here?
I think our last witness restated the evidence in this case anyway. I'm not going to go a second rehash anyway.
Understood. With respect to DNA, were you, as chief of police, the one that authorized the testing of any evidence that was tested in this case?
yes, sir.
And can you tell the jury why you would be the one that would say yes or no?
Well, I mean, one, it's got financial value, right? I mean, what does our budget look like? Where are we sending it to? What are the logistics involved around that? So I have to do that. That we value the weight of that evidence. In the case that we're working, we said send it all, and it was my authority to take everything that we received and to try to get it tested.
All right. Now, taking a look at Tim Herrington's apartment, did you send investigators down to try to obtain samples from Tim Herrington's apartment?
We did.
All right. And were some of those samples sent down to the lab to be tested?
Yes.
And it's scientific evidence. It requires professionals to do. There's going to be an expense associated with that, correct?
Yes, sir.
Now, at the time that those samples were obtained by law enforcement, did you have any concerns about the chances of finding anything of evidentiary value as a result?
Absolutely.
What were your concerns?
Time. I mean, 14 days. We can't predict who's come, who's gone, what's happened in there. The conditions have all changed over that period of time. That's a huge concern for us.
All right. And when you talk about time, what is that time range?
It was 14 days from the initial investigation beginning when a welfare concern started till July the 22nd when we knocked on Tim Herrington's door.
Were you in control of that crime scene from July 8th to July the 22nd?
No, sir.
Who was in control of that crime scene from July 8th to July 22nd?
Tim Herrington.
Rephrase the question.
Do you know who was in control of Tim Herrington's apartment from July 8th to July 22nd?
Tim Herrington.
Okay. Now, were you aware of Well, let me ask you this. What are some types of things that could be of concern if you're not in control of that crime scene?
Well, for not,
Narrative and narrative question. What are some of the things that you'd be concerned about if we're not in control of?
I'm gonna
Leading
allow him to,
question, narrative,
I'm,
asking for narrative
I'm
response.
gonna allow him to ask that question.
I'm concerned about everything. There's no control when we are dispatched to a location for a crime. It's imperative that we lock it down as quick as possible. If you don't, every factor is important.
Specifically with respect to DNA, trace evidence, that kind of thing.
It's, yes, sir. All of those things are going to be impacted.
All right. Did you have, as part of your investigation, any heightened concerns about any of those factors based on the conversation between Tim Herrington and Jay Lee between 4 and 7/28 on July the 8th, 2022?
Yes, Jay Lee tells him that he left a sample on his floor and he needed to clean it up. That was an obvious statement made.
And what about that would concern you about the evidentiary value of any kind of biological evidence that may be in Tim Harrington's apartment?
That it's been cleaned.
Okay. Now then, the box truck, were you aware as part of the investigation that you authorized testing of samples taken from the box truck?
Yes, sir.
Were you concerned about whether any of those items gathered would have any evidentiary value for you?
Yes, we're very concerned.
Why?
Again, you have time. You have admission of multiple moves. We don't even know if the contents that were in the truck the day we recovered it was the same contents that was in the truck July 8th. That amount of time and that amount of people that had access to it and the multiple moves.
All right. And the time frame from July 8th to when samples were taken from the box truck, do you know that range?
The 24th or 26th, it was close to 3 weeks.
All right. I believe there were some moving blankets in the back of the box truck that were gathered.
Yes, sir.
Would you have had any way to know when those blankets were put in there?
No, sir.
All right. With respect to, who was in control of the box truck from July the 8th to July the 24th, 2022?
I'm not sure. We know that Tim had it on the 8th, but he had other partners who had access to it, and I believe it was Tyson King that we stopped the day that had the truck. So we know multiple people had the truck and had access to it.
All right, and then Tim Harrington's Ford Escape, were samples gathered out of that?
Yes, sir.
All right, do you know, are you familiar with the examination of the back of that vehicle?
A little bit to my knowledge, yes, sir.
All right, and what did you know about that played into your decision to have samples tested out of that?
They used a tactic that identified, and again, this is not my skill set, but they used a tactic to identify something that brought color out that led our investigators to believe there was presence of something there at some point. That was the reason that we chose to go ahead and do samples on that.
Now, with respect to Jay Lee's car, I believe there was an initial search for the contents, the credit cards, the cash, and then that was later sent to the crime lab.
Yes, sir.
To obtain samples for DNA testing. Is that correct?
That's correct.
All right. And you authorized some testing of items or samples that were taken from Jay Lee's vehicle, correct?
Correct.
All right. did you have any concerns about whether there would be anything of any evidentiary value as a result of that DNA testing?
Yeah, I mean, we showed that Tim was in that car, and you know, again, we talk about transfer and DNA, so it's anytime elements have changed, you have to understand the changing of what's going to take place and what you can extract is going to be adjusted.
Is there anything else in the investigation or anything else that would have indicated you may not have been able to find anything of value in Jaylee's car?
One of the things that concerned me was when we saw the video from Molly Bar Trails, you see Tim in a sweatshirt, but you also see some type of cloth material over his shoulders, which it looks like he's running in. And can that be placed on the steering wheel? Is that used to cover up fingerprints or any other trace? That was a big concern to us.
I don't understand exactly how we're getting to the point of asking a question about something and getting into.
I'm going to ask him, let him respond specifically to your questions. If you have a question about some item or something, let him explain it from there, okay?
Thank you. Now, have you seen the video or reviewed the video of Jaylee leaving Campus Walk Apartments 2 times
Yes, sir.
in July 8th, 2022?
Yes, sir.
All right. Who was in control of the key to his car and his cell phone at that time?
Jaylee.
All right. Who would have been, do you have any proof as part of your investigation as to who was in control of the key to Jaylee's car and his cell phone at 7:28 on July 8th, 2022?
Tim Herrington. We saw the video of, we saw the car, so Jaylee's car driving, Jaylee's phone is tracking with that car. We see the car going to Molly Bar Trails. We see Tim Herrington running out. All of that is exactly all in between 7:02-ish to 7:28. And at 7:28, there's no more access to Jaylee's phone.
All right. Now, can you tell the jury how many agencies, law enforcement or otherwise, were involved in this investigation?
From local, state, and federal, I counted as easy as 27 to 30 that I saw actively involved in this case, from us to UPD to the Sheriff's Department, to, again, state partners and our federal partners that assisted with us.
And that's from every aspect, from tracking down leads, tips, ruling people out, to the testing of evidence.
Yes, sir.
Now, on July the 8th through July 11th, even up to the last social media post about asking the public for any information about Jaylee, missing person, y'all, including other agencies, conducted searches of specific sites.
Yes, sir.
What was the purpose of those searches?
It was really just to leave no stone unturned. I mean, you get a tip in, or, when you start an investigation, you started from what evidence do you have? So we knew we had a car. We knew that car was at Molly Bar Trails. And we knew where Jaylee lived. We took those 3 starting points and then broadened our search from there. Again, as tips came in, we would run those down, but we looked in wooded areas, we looked in dumpsters, we knocked and talked on apartments, we canvassed everything that we could possibly canvass, and as the days went on, we would expand those to, what about the next apartment complex over? Or what about, again, if a park is nearby, if there's anything that would lead us to a probability, we searched all those areas.
All right. And if you could, speak to the jury about the difference between the terms search and rescue.
Search to me is what can you find? You're kind of looking for anything. At this point, we're kind of looking for a key that looks about twice the size of your thumb, right? So we're looking for that. We're looking for a cell phone. We're looking for Jay Lee. We're looking for any of the articles of clothing that he's reported in being seen in last. All those things are items of what you would look for on a search. When you get into search and rescue, you sometimes have an idea of an exact location or an exact proximity of what you're trying to gather. And so you go from search to rescue because you feel like you're getting something out of that.
All right. Now, the last searches that were conducted within the last 3 months, did you authorize those?
I did.
All right. Did you inquire from the state whether that would have any effect on the trial?
Yes.
All right. Were you aware that any of that information would have to be shared to the defense?
Yes, sir.
All right. Some of the areas that were searched, were they controlled by or near family members of the defendant?
Yes, sir.
Would those searches have been conducted, would be open and obvious?
Yes, sir. Broad daylight.
Now, those searches that were recent, what were you looking for?
Again, anything of evidentiary value. You're obviously, your main priority is Jay Lee, but you're looking for anything that could give you evidence to point you in another direction, to continue giving you feedback.
And the main importance was Jay Lee. Why now? July, that he went missing July 8th, 2022. Why are you still looking for Jay Lee's body?
We've been looking for Jay Lee's body for 2 years, and we're not going to stop till we find him. I can guarantee you that.
Now, at this point, taking all of what you've learned from the investigation, at what point, taking all that into account, can you pinpoint, based on any proof that you have, the moment that Jay Lee was no longer a missing person, but a victim of a crime?
I think once we begin to gather enough information, you always.
Your Honor, now I'm responsible to the question. You're asking me to pinpoint times.
I'm gonna give you a chance to try to pinpoint the time and then explain why you felt that way.
We didn't get to the point that we felt like we went from a welfare concern, missing person.
Your Honor, you need to answer the question. You can pinpoint time when Jay Lee.
Go ahead and either rephrase the question or answer that question first.
Can you pinpoint a time based on your investigation when Jay Lee went from a missing person to a victim of a crime?
From the moment that we gave Tim Herring the opportunity to tell the truth and he couldn't, and he lied, and we backed that up, we knew then that it went from a missing person to a dead body.
And I want to be more specific about that. I'm looking for not when during the course of the investigation you believe that Jay Lee went from being a missing person to a victim of a crime, but now, at what point, what time frame would you tell the ladies and gentlemen of the jury, that you have proof that Jay Lee was a victim of a crime? Was that on July the 8th? And what time? Pinpoint the time.
So the timing is from 0600 to 728 from the time that we know Jay Lee's alive and he messages open to the time at 728 when his phone is done and there's no digital footprint of Jay Lee ever again.
Okay. And what proof would you point the jury to that would establish that he was no longer with us at that point?
During that timeline, I looked at, we've shown you motive. We've shown you that Jay Lee was lured over, that there was...
Hang on, there's objection.
Make a closing argument from the stand, Your Honor.
No, he's not.
Hang on.
The question is, what proof do you have at that point in time, the time frame from 6 o'clock in the morning to 7:28, that Jay Lee was the victim of a crime, and he was beginning to say,
Ask him what happened between 6 o'clock in the morning and 7:28.
I want to make sure, my objection is, witness can't say what we've shown you. He had been sitting in his courtroom listening to the evidence.
I understand that. I'm going to let him talk about what evidence the Oxford Police Department has of what occurred between 6 o'clock in the morning and 7:28 in the morning on July the 8th.
So our evidence is motive. Tim Herrington didn't want to be out of being on the down low. He lured Jay Lee over to his apartment with an alternate Red Eye 24 account that even in Jay Lee's words, he's felt like he's being lured over. Jay Lee says, I'll come later tonight. Tim says, nope, gotta come now because I'm not going to be here later tonight. That's a lie because he was in Oxford later that night. We have
hold on one second, Chief. He's being responsive to the question. The circumstances matter.
I'm going to allow him to testify. Go ahead.
He had the blocked account. He says, Jay Lee says, I'll come over later tonight. Tim says, no, gotta come now because I'm not going to be here, which was a lie. He was in Oxford that night. Jay Lee tells him he's coming, says open, while Tim is Googling how to strangle someone. Then 30 some odd minutes later, Tim leaves and goes to Walmart to get duct tape, then leaves and goes and gets a box truck, then comes back to his apartment, the last known location that we know Jay Lee was at. He then stages that car. We see him running out of Molly Bar trails.
This is completely inconsistent with the testimony that's been provided.
I'm going to ask that you not allow a narrative form, but you direct him at questioning what happened then, Okay?
He's got personal knowledge of investigation.
Asked it instead of a narrative response. The response should be a question followed by an answer of what next, what happened next. Okay?
Yes, sir. And I will ask you this. All that you just told the jury, you have personal knowledge of.
Yes, sir.
Okay.
He was present at the time of these events.
He's indicated he's been in charge, he has knowledge of the investigation.
Do you know from the investigation what significance July 8, 2022 had for Jay Lee and Stephanie Lee?
It was the day that their son was taken from him, and it was her birthday.
Were you aware of the type of relationship that Jay Lee had with his mother, Stephanie?
Yes, they talked.
What's
Were
wrong
you
with the
aware
question?
of the nature of the relationship that Jay Lee had
I'm gonna
with
let-
his mother, Stephanie?
Okay, go ahead.
Yes, they were very close. They spoke all the time, multiple times a day, often.
And you were aware of what day it was for Stephanie Lee?
It's her birthday.
After 7:28, well, actually, after 6:03, Well, let me ask you this. Do you know when the last message Jay Lee ever sent from his phone?
It was a message of open.
Do you know what time that was?
It was around 6:03 that morning.
At any point after that, were you aware of any other message that came from Jay Lee's phone?
No.
Course indulgence. Into the witness.
All right, we've been out here a while, let's take a look.
I'm sorry, Your Honor. If I may,
You may.
thank you.
You
We were
under the
talking,
wire.
I'm sorry,
You got in under the wire anyway, go ahead.
thank you. You were talking about pinpointing the time based on the investigation as to when Jay Lee was the victim of a crime. And that range was 6:03 to 7:28.
Yes, sir.
All right. At all times during that time frame, was Jay Lee and Tim Herrington, those events, did they all occur in Lafayette County?
Yes, sir.
Okay. State of Mississippi.
Yes, sir.
Tend to the witness.
All right, we're gonna take a little break, go out there a while. Remember court instructions, don't talk about the case, don't anyone talk about the case with you. Don't form or express any opinions. Don't, investigate. Don't look at any media posts. Did the, well, at some point today, the defense moved to introduce into evidence the crime lab report, and I'm familiar with both arguments made in support and in opposition to the introduction of that report. I think the facts in this case are more analysis to Odom versus State 383 Southern 3rd 322, where the defense was trying to introduce a report from the crime lab report without a witness from the crime lab. The witness who was questioned about this had many times he said, I don't know what that means. I haven't seen that. Well, I may have seen the report, but I'm not aware of this, that, and I think that there's nothing precluding the defense from calling somebody. I'd probably let you call anybody, any of the crime labs involved in it that had some expertise, whether it be the state crime lab, scales lab, or anybody like that, to authenticate the document and give us some basis of how it was created and things like that. But I'm going to deny the admissions, and also in Odom versus State, this court stated, further it is noteworthy that despite this exclusion, the jury still heard testimony that in fact paint samples were collected in the victim's car and Odom's van and compared to each other. I think the jury, I've allowed, I think, extensive cross-examination on the fact that there had been no DNA, fingerprints, and things like that from at least 2 and maybe 3 witnesses. Juries have been allowed to hear this testimony. It's just whether or not the report is being introduced or not.
John, for the record, so we can be perfectly clear, it's not that this witness probably ought to step out while I make this argument.
Okay, won't you step out anyway?
It's not the fact that there's no DNA recovered in this case. That's not the evidence. The evidence so far is from Detective Baker, and he's identified in the report, DNA samples were recovered that don't implicate my client in certain areas. So that's, I think, needs to be cleared up in the record. We're going to go through with this witness. Unfortunately, it's going to take a lot longer since he testified he wouldn't expect to find any DNA samples when, in fact, we've got all kind of DNA samples, DNA profiles located at various locations. So I want the record to be clear that it's not that we don't have DNA for Mr. Herrington, Jay Lee, and other individuals, other donors unidentified everywhere. It's just the fact that there's no DNA samples implicating my client in any areas he shouldn't be, and Jay Lee is in the areas he's supposed to be.
And I understand that, and I'm gonna let you cross-examine extensively on the report, the results of the report, what was asked for, what was sampled, but the report itself going to the jury is I'm gonna let you cross-examine the witnesses, but I'm not gonna let you introduce the report without a sponsoring witness.
And I will say that he mischaracterized the testimony from this witness. What he said was that he had concerns about the quality of the evidentiary value based on circumstances.
I wrote it down. He said, wouldn't expect to have any results.
The record will speak for itself. I'm not going to pretend I know exactly what anybody said.
I'll cross him and ask him to clear it up, Your Honor, before I move forward in that line of question.
All right. But I'm going to give you extensive latitude in cross-examination but the report itself will not be admitted without the sponsoring witness that can talk about procedure of testing and things like that.
Your Honor, I do want to.
Well, I'll go further to say that I don't think the fact that this officer or these officers have a crime lab report in their possession makes them the custodian of the record.
I understand the court's ruling. I want to be clear on the record, Your Honor. His statement was, as I recall, there was no evidence in the bag, and I'll ask him about it along with.
All right, I'm gonna give you wide latitude to y'all.
Thank you.
All right, how long we been out? All right, long enough for the jury to come back anyway. All right, show them in. All right, everybody good on the jury? All right, you may cross-examine for the defense. I think. Oh yeah, let's get the chief back. We weren't going to start without you. You remain under the same oath, and you can cross-examine it with you.
Good morning, Chief. How you doing?
I'm good, sir. How are you?
Fine. I want to clarify some things. I want to make sure. I gathered that your information that you got initially on this particular case, you said earlier there was a joint effort between UPD and OPD early on, correct?
Yes, sir.
And that would have been shortly after Ms. Lee came to Oxford, is that correct? Came to y'all? Sometime in the 8th, I guess I would say.
I believe Ms. Lee reached out to the university on the 8th.
Okay, all right. And you indicated you still had the exhibit.
Yes, sir.
May I approach you?
You may.
Chief, this representation of the Facebook post that is introduced as State's Exhibit 101, all the content in here as far as post engagements and account center accounts received, all these numbers on here, are those representations that were done at the time of this investigation, or is this something you printed out recently? I'm not talking about the post.
Sure.
But all the information that apparently the likes and things of that nature, that represents what you printed out during your investigation or in preparation to come into court here today?
That was, I believe, a May 2024 printout, or analytics came from that month.
All right. And I want to be sure, all the information that, and I ain't much, I don't even have Twitter, okay? So this 19,875, all this stuff is the record of that Twitter account in May of 2024?
Yes, sir.
All right, it's not in relationship to the July 8th, 2022 date, correct?
I believe, yes, where post engagements are going to be more of your specifics. If we pulled up each individual post, and I'm not sure any of those.
I guess my question is,
The majority of what you're asking is here, found here at the bottom.
Right.
These analytics would have been what was the total touch point from the time we printed that, from the time that post was made to the time we printed it?
Notwithstanding that fact, there was a lot of interest shortly after Jay Lee's disappearance, correct?
Yes, sir.
And there was a lot of media coverage, and it would be a fair statement that university student population from the 9th, when it was first reported, even up until now, constantly, as evidenced by this particular exhibit, a lot of activity keeping up with this particular incident locally, right?
Yes, sir.
Okay. And I want to talk to you a little bit about what you stated about the DNA, collection of DNA evidence. Have you reviewed the report that came back from Scales Laboratory?
I don't know that I have seen Scales' report.
All right. But you testified on direct examination that you wouldn't anticipate gathering, and I wrote it down, correct me if I'm wrong, no evidentiary value, because there was a delay in time from July the 8th until somewhere around 2022 before you collected any evidence from Mr. Herrington's apartment. Is that what you testified to?
What was that question?
The question is it your representation that you would not anticipate any evidence, any samples having any evidentiary value if they were collected from July the 22nd, 24th, or 25th, if you were concerned about a crime scene or a potential crime scene, July the 8th, 2022.
All right, you gave me multiple dates, so.
July the 8th is the date that you indicated that Jay Lee came up missing, correct?
Yes, sir.
July the 22nd, Mr. Herrington is arrested, correct?
Yes, sir.
July the 23rd, 22nd, samples were collected out of his apartment, correct? For purposes of sending off a DNA, saliva, blood, whatever.
Yes,
right?
sir.
You weren't just doing DNA samples for purpose of one thing. You were doing a crime scene investigation, correct?
Correct.
All right. So I think your testimony was that you'd be concerned about there being any evidentiary value because of the 14-day period, right?
Yeah, I think what I said was you have to take into the fact that the results are going to be diminished after time and elements and things that happen.
Are you familiar with the fact that, have you been informed that Scales Laboratory has provided a report representing what their findings were?
Yes, sir.
And did you know that they found evidence of value in Timmy Herrington's apartment, DNA profiles at his apartment that was collected 14 days from the time from July the 8th? Did you know that before you testified here today?
That they found?
Yeah.
If you have something, I'd love to look at it.
Sure. You haven't looked at the report?
Sir, there's thousands of reports. I'd like to see the one you're referencing.
Okay, I'll have to find out what exhibit number it is.
You're probably looking at 103.
You said you hadn't seen the report, but I'm going to hand you what they provided. ID, it states exhibit 103. I don't expect that you're going to be able to testify that you've ever reviewed it. You ever seen that report before?
I don't believe so.
May I sit down? never seen a report before?
I don't know that I saw it. I've seen it.
Well, how is it that you can come in here and testify, Chief? I'm just curious, and I'm not gonna be argumentative with you. But you wouldn't expect to have any DNA profiles of evidentiary value in this case. If you have it,
Your Honor, object to the formal question. That's a mischaracterization of the testimony that he was, to say that he asked.
Y'all may have noticed I forgot to put the hearing aids in this morning. I spent a lot of time looking like Dumbo. Go ahead.
The question was, putting words in the witness's mouth as if he said he would expect to find no evidentiary value. That was not the testimony of this witness. It's an improper question.
I'll rephrase it.
There you
Your Honor.
go.
I
That
thought
makes
that's
it
what
easy.
you testified to. Chief, and again, I'm not trying to be argumentative. Would you go to page 10 of the exhibit
Okay.
and read read the bottom where it says conclusion. Just read it, please.
Your Honor,
I'm not,
I don't know if he's saying read it out loud.
just read it to yourself, I'm sorry.
Read it out loud.
That's,
Did I object?
all right, we read it to yourself right now.
You had the opportunity to read it, Chief.
Yes, sir.
I go to the next page, page 11, and I certainly don't expect you to understand some of the terms in here, but because it takes a while to read this report, but go to number 10. You don't have to really look at number 9. Read number 10 on the report.
Yes, sir.
Correct me if I'm wrong. The DNA profile identified in number 10 indicated that it came from the interior back cargo door swab, correct?
Yes, sir.
Item 001T2, correct?
Objection, Your Honor.
Item 10,
Objection is, further I can.
Chief, correct me if I'm wrong. Item 10 indicates that the partial male DNA profile obtained from the interior back cargo door swab and item 00T2 do not match Jimmie Herrington's DNA profile.
Objection to the
Correct?
what vehicle are we talking about?
I'm fixing to get to that when I get done with the
And Your
report.
Honor, I don't think we're there yet. He's asked the witness to review the document, and then he's gone straight into testifying on the document says.
I'm gonna let him, let him
You
ask.
should ask if these.
He opened this up on cross.
He has been tendered in this case, court feels, to somebody to sum up the evidence anyway. And if you're gonna sum up the evidence, you gotta take cross-examination on the evidence.
Correct me if I'm wrong, Chief. It says the partial DNA profiles obtained from the interior back cargo door swab and item 001T2 do not match Jimmie Herrington's DNA profile or the major contributor DNA profile obtained from Jimmie Lee's toothbrush. Is that what it says?
That is what it says.
All right. Now, I could go down every one of these items if need be. Just flip through the page. 11, 12, and page 13. Tell the court how many items are at the conclusion of the list on page 13 of 13. Correct me if I'm wrong, there's 35 items listed in this report, correct?
There are 35 numbers. I have never seen a document like this before, so I don't know how it's labeled as far as, are they saying this is sample 1, sample 2?
35.
I do see 35 on there.
35 items that the Scales Laboratory gave conclusions on as to some type of testing, apparently in this report, correct?
Yes, sir.
All right. And you'll look at item number 35. It indicates, already in the evidence in this trial, that hair was collected from the t-shirt. These hairs were not examined, however, they can be examined upon request, correct?
Yes, sir.
34, read that if you would, please, to yourself. You had the opportunity to read it?
Yes, sir.
Now, I don't know if you're familiar with the location of these items that were identified in 34, but it appears to me in this report, as reported by George Shiro, that those items were not examined. The black Ford Fusion keys, card, driver's license, and receipts.
Objection, Your Honor, it's a mischaracterization. It's not proof.
What's in the report?
It's in, I'm reading the report, that it was not examined and could be examined upon request. We've already had testimony about it. Your Honor.
I think we've heard testimony that, I think we can say that the keys from the Ford vehicle.
Those items, according to this report, could be examined upon request, correct?
Yes, sir.
Did you make the decision, or did someone under your direction make any representations not to test those items?
No, sir. It was our understanding that everything was going to be tested. I've got a bill for $30,000 that what we sent was to be tested.
But it's a fair representation that those items were not tested, correct?
Correct.
All right. I want you to go to item number item number 24 on the list, if you would, please.
Are you still under conclusions?
Yes, that's all, we're sticking to conclusions. That's all we're gonna talk about.
Okay.
Read that pertains to the sweatpants. As far as the stain on the sweatpants, I'm just giving examples that there were DNA items sent to the lab, came back with results. Read that for me, please, as to the sweatpants. Have you had a chance to read it to yourself?
Working through it. Okay.
And it appears to indicate that there were 3 DNA profiles on the sweatpants stain from Mr. Herrington's apartment, that Timmy Herrington can't be excluded, but Jay Lee was excluded, right?
Sir, I've never seen this. I don't understand how to truly interpret this. I've never did an analysis of DNA from.
Have you had an opportunity to read it?
Yeah, I am, but it is very confusing.
Okay. I guess my question is, Chief, your previous testimony that you wouldn't expect to find any DNA profiles from the 14-day delay is not represented in this report.
That's not what I said.
Okay.
What I said was time, manner, circumstances diminished. I never said it was a 0.
Okay. Well, in this instance, the report indicates that they were successful in providing DNA profiles and a report in this particular case, right?
Ask an answer. He said he can't read the report, can't offer any conclusions based on the report.
I'm going to sustain the objection.
Have you had any information provided to you by Detective Baker after he's reviewed the report that Jay Lee's DNA, saliva, hair, urine, or any trace evidence showed anything whatsoever that it wasn't where it was supposed to be, and that Mr. Harris's DNA where it was supposed to be? Has anything been reported to you as far as any crime lab report that there's any trace evidence at all, implicating my client in anything whatsoever pertaining to the investigation of this case? Trace evidence. I'm not talking about the videos or whatever. I'm talking about trace evidence, Chief.
No, sir.
And it's a fair statement that y'all got a 13-page report back pertaining to everything that was recovered, right?
Yes, sir.
You indicated previously that you met regularly with the officers on this case. Y'all make decisions on a regular basis, right?
Yes, sir.
At 27 agencies, according to your testimony, involved in this investigation. Is that a fair statement?
No, sir. I said 27 law enforcement personnel that I saw
Oh,
on a
I
regular
thought you-
basis, not agencies.
I'm sorry, but were you aware of the content of the statements of any of those persons of interest as it related to this case?
We would debrief, yes, sir.
All right. Now, a person of interest, Chief, is not necessarily somebody that's a suspect. Is it? A person of interest includes somebody that may have information, right?
Yes,
That
sir.
leads to a suspect, right?
A person of interest could come in from like a tip or anything that someone said, hey, you need to go talk to this person. That's interesting to us. We would look at that as a person of interest.
Were you informed that individuals that had come in contact with Jay Lee were given deceptive information about their connection to him I'm not talking about whether or not they were later eliminated as a suspect. Was your investigation impeded by virtue of the fact that certain people weren't being as cooperative early on as you felt like they should have been?
No, sir.
At all?
If people were not cooperating with us? No, sir.
Well, can you explain why in McGuire's report, it states in the report that certain individuals are being quote-unquote deceptive about their connection to Jay Lee. These are some of his friends. Can you explain to me why, or was it reported to you that those individuals were being deceptive and providing false information?
So Shayla McGuire doesn't work for the city of Oxford. So if she filed something, it would be with the university. If you have something that she has, I'll be happy to look at it, but she works for the university police.
I understand that, but y'all were working together as a joint effort. Did you have any information that individuals that were reporting to UPD and OPD investigators weren't being completely honest about their relationship with Jay Lee?
No, sir. I mean, I don't understand what you're asking. Shayla McGuire, again, doesn't work for us, so if she has something.
Any information?
Everyone that we met with, we didn't have anybody that did interview with us.
Okay. Are you familiar with the fact that Detective Baker had conversations with individuals with UPD involved in an investigation and interviews together with certain individuals?
I'm sure I'm sure we met with different people. I don't know who all Detective Baker met with.
What reports have you reviewed in this particular case from your agency? I'm just asking, Chief.
Mostly our reports.
You haven't reviewed any of the UPD reports?
No, sir. That would have went through their chain of command.
Now, the report that you have, I believe it's a 133-page report, correct? Something like that. Have you reviewed that?
No, sir. Not all those documents.
All right. Did you review with anybody in your office the interview process or the process of eliminating a point of interest, Mr. Timberland Mathis? That name you know who that is?
Yes, sir. I've heard his name.
All right. Did you review the interview process by which Mr. Mathis was eliminated as a person of interest?
I did not watch that interview, no, sir.
All right. Have you reviewed any reports by which Mr. Mathis was eliminated as a person of interest?
No, sir. I believe I met with our team. Again, we would do daily updates, and so if we did anything, it would be a meeting together.
Okay. Were you informed that Mr. Mathis was being deceptive during the course of his interview?
No, sir.
And what about any conversations or interviews with Jose Reyes or Jamie Towns, which is Jay Lee's roommate? He's a person of interest just because he's a roommate, correct? Y'all interviewed him, right?
That name sounds familiar.
Okay. And Jamie Towns, another Khalid Fears. You're familiar with the interview with Khalid Fears, right?
I know we talked to Jose Reyes. I know Fears for sure.
Okay. And as far as Mr. Fears' statement, it appears that he has provided some information pertaining to his relationship or his connection to Mr. Lee that really wasn't 100% true early on in the investigation, right?
I'm not aware of that.
Okay. If there's a report that represented that he may not provided accurate information, you wouldn't have any idea about that.
I would love to see it. I don't have that report.
Now, if you would, tell me, you indicated earlier that the investigation, the reporting process that started between UPD and OPD, that was early on. Y'all were sharing information between each other. Fair statement?
Yes, sir.
Okay. And the report that you're talking about as far as the press release, do you know whether or not the UPD press release came out before y'all's?
The first one?
Yes.
Yes, sir, it would have had to because we shared it.
Okay. Were you familiar with the fact that Mr. Mathis provided information to the investigators that he knew that the report came out the day before the report actually came out? Did that come to your attention at all?
No, sir. Again, if you're referencing a report, I'd love to read it.
I got you. But it's not a report that you haven't read the entire file of the UPD file, correct?
No, sir.
Or the OPD file?
Not from start to finish.
Okay. When's the last time you reviewed a report of the OPD file?
I mean, as we do trial prep, I'm looking through notes, but I'm not going from
Not looking at the report.
the entirety.
Is it important to provide every time an officer does something as far as an investigation on a particular case to whether or not they're interviewing a witness, they would keep up with that, place it in a report? Is that important?
If they're interviewing someone?
Yeah.
Yes, sir. We make reports.
And the information that you provided on direct examination pertaining to the searches, I believe those searches were conducted on November the 7th, 2024, the most recent searches, I believe at Lafayette Place here in Oxford, also in Grenada at Lincoln, on Lincoln Road, and somewhere, quote unquote, in a wooded area on Perry Road in Grenada County, November the 7th. Is that when those things occurred?
I don't believe Lafayette Place was November the 7th. I believe that may have been in September.
What date was it?
I believe in September of this year.
All right, September this year.
Yes, sir.
It was September this year, but the most recent searches in Grenada County were on Lincoln Road and Perry Road, November the 7th of this year, right?
Yes, sir.
Can you explain to the jury, the court, and myself, and even the DA, why that was not reduced to writing, placed in any report?
Sure. So, Lincoln Road and the area around Perry Road had already been searched previously. We had already been there. Nothing changed in November of 2024. It's very similar to us. We get calls all the time about a crime or an event that has happened. We show up and there's nothing there. And we call it HBO. It's handled by officer. We reported everything that we've done on Perry and Lincoln Road. There was nothing new, nothing of evidentiary value that we used. There was nothing to add to that report. That's why there's not a report.
Well, Chief, there's a lot of other reports in your file that indicate nothing of evidentiary value was found prior to these last two searches that have reports in. My question is not whether or not you didn't find anything of evidentiary value. Why did you not file a report that you didn't find anything of evidentiary value on those particular searches?
Because we had already previously searched those locations, nothing changed. There was nothing to add to that original search.
So that's why you didn't file a report?
On November the 24th
On November the 7th.
of 2024,
That's correct. In the September date.
yes, sir. We've already searched those locations.
Are there any other report? Did you authorize or direct them not to file a report, Chief, or they did that on their own?
No, sir. It's again, like I said, it's standard practice. We get a call about a careless driver on XYZ location. We go to that location. If we don't find anything, there is nothing to report. We go back 10-8 HBO.
Chief, you indicated that you wouldn't report anything since there was anything of value, but you would have reported something on the November 7th report if you had found something of value.
Yes,
Correct?
sir.
You agree with me, do you not? By you not finding anything of value is something that may be valuable to a defendant.
I'm not understanding your question.
Well, you think it may be valuable that if you've received information to go search a place, regardless you had already searched it before or not, may be valuable to a criminal defendant to know that you went back down there or went down there the first time.
And again, I think we reported that. That information was shared.
Of the November the 7th, 2024 search?
We spoke with the DA's office on that. We shared information.
Well, can you explain to me, according to the officer's testimony, I just testified the first time that we heard about it was 2 weeks ago yesterday on a question that I asked an officer whether or not there'd been a Grenada and Lafayette Place for searches. First time it was ever revealed was in a court of law. How can you explain that, Chief?
All I can tell you is we went there to search. We didn't find anything. There was nothing to report.
So, let's talk about some other evidence in this case. If there's evidence that an officer has gathered, retrieved it, evaluated it, and personally has determined that it's unreliable, should that be placed in a report?
That officer collected?
Collected evidence, let's say from a search warrant. Collected evidence from a search warrant, got it, looked at it, and he talked to somebody or made a determination, even if the investigation revealed that it was unreliable. Should he put that in a report?
You're asking me a hypothetical?
I'm asking you as the chief of police for Oxford Police Department, if one of your officers gathers evidence,
And he logged that evidence. He logged it as evidence.
I've got a copy of it, that they got it.
But that's a
Logged
report
that
then, right?
evidence. Should he report that he gathered that evidence?
You said you have a copy of it.
My point is, I'm asking you, should he report, if he makes the determination that that evidence is unreliable, should he put that in a report, just like a statement from somebody? You take a statement from somebody, put it in a report if you think someone's being deceptive, right, or dishonest, right? You put that in a report. You evaluate that person's statement.
That sounds like someone's opinion. That doesn't sound like evidence. You're changing up on me. You're saying they gathered something, and now you're saying they perceived something. That's different. So perception may not go in a
Well, if you had
report.
an officer, one of your officers testify under oath that they gathered evidence, reviewed it, in their opinion, after talking to other people, it was unreliable, shouldn't they put that in a report that they determined that they gathered it and they determined that it was unreliable?
And our officer put that in a report, is what you're saying.
No. If he didn't, would he have done something against your policy? He gathered the evidence, Chief. He took it. He looked at it. He determined, in his opinion, that it was unreliable. Should he report that he gathered it, that he evaluated it, and that he determined that it was unreliable, Chief? It's a simple question.
It's really not. If we're out on a search, and again, all of these locations, we ran across all kinds of things on the search. You may look at it, I may see a AA battery Is that a part? I find it, evaluate it. Do I need to log that? Do I need to keep that? No. You move on. I'm not going to write every time I saw someone's cigarette on the ground or whatever we may have found in the woods. Yes, you have to evaluate what you see, but I'm not going to put everything that I came in contact if it was not pertinent to the investigation.
Hang on.
The objection to the question is that it ultimately, it goes to the credibility and weight of the evidence, provenance of the jury on each individual piece of evidence. And the chief has already answered the question too, as far as policy.
If you've got a more specific question you'd like to, if you got a more specific question you want to ask the witness, ask it. If you don't, move on.
Chief, if you execute the search warrant on the residence Jimmie Herrington on July the 22nd, his property inside his apartment, and the resident key lock audit for his apartment. Executed search warrants for all three of those. And if you got returns on all three of those, right? Shouldn't an officer provide a report about the return on those search warrants?
Whatever we collect, we put in the return.
Okay. Now, once he evaluated that evidence, in his opinion, if he decided the lock audit's not reliable, or we messed up on the computer that was seized from Mr. Harrington's apartment, or if we opened the door too early on his car before the execution of the search warrant, those items should be listed in a report as to how he conducted his investigation, correct?
Objection, Your Honor.
Yeah.
Confusing question, compound question.
I think it's a reasonable question for cross-examination.
So you asked multiple questions.
I asked one question.
No, she asked
Give me
multiple
the
questions.
information to answer the question.
You asked multiple questions. You said, should an officer put evidentiary, so if I get something, should I put it in there? You also said, should they talk about when they opened a car door or when they pulled? Those are all different things. They're not going to timestamp when I opened a car door. That there's other mechanisms of evidence that they use for that, for cameras or video.
Here's my basic question, Chief. I laid out stuff so I think you understand. Executed a search warrant on July the 22nd, 2022, pertaining to evidence collected on that day, the same day that Mr. Herrington was arrested. That evidence was collected and logged, placed in evidence, and examined. If anything that was collected that day, whatever it was, piece of evidence was collected, and an officer drew an opinion at any point in time about the veracity of it or any of the problems with the evidence, shouldn't that be placed in a report? Yes or no?
I can't speak on his opinion. I can't make an opinion assessment of should he write that in his report. That officer has to say.
I'll move on, Your Honor.
Well, either ask a specific question about a specific item or move on.
The lock audit that was provided as a return on the search warrant on July the 22nd. Are you familiar with the lock audit?
Yes.
All right. Are you familiar with the fact that the lock audit search was executed and a return was provided to the Oxford Police Department?
I've not seen that. I know we asked for the lock audit.
If there was a search of the lock audit and a return done on the lock audit, should there have been a report by the officer that did that particular return on the lock audit?
Sounds like we did. We filed for it and we returned it. We
Yes.
filed for it. Yes, we filed for it and we returned it. That's the report.
After the officer that got it, Detective Baker got it, and assessed the lock audit, if he did any further investigation on that particular lock audit, resident lock audit, any further investigation on it at all, should it be placed in a report?
Based off the information he got on the lock audit, he should file what he knows on the lock audit.
Correct. And that's consistent with any other part of the investigation for Oxford Police Department, correct? You gathered information, got that information, if you provided evidence, you gathered evidence, if there's anything about that evidence that's remarkable, it should be placed in a report, right?
Anything that we are using as evidentiary value, we file.
Chief, I want to go over a little bit of the testimony that you stated on direct examination. Have you, to the extent that you know about conversations between Jay Lee and Jimmie Herrington prior to July the 8th of 2022, have you reviewed any of the text messages, Instagram?
No, sir.
You haven't reviewed any of that?
No, sir.
Have you reviewed the Snapchat conversations between Jay Lee and other individuals prior to July the 8th, 2022?
No, sir.
Have you reviewed any of Jay Lee's Snapchat, or any other platform, social platform of Jay Lee prior to July the 8th, 2022?
No, sir.
So what I'm assuming, your direct testimony about conversations that they had, things of that nature, or things that reported to you either through officers or stuff that you had read in the report as to what occurred that evening, correct?
On July 8th.
Conversations July 8th.
I've seen the July 8th conversations. You asked what I saw prior to July 8th.
July or prior to July the 8th.
I've not seen anything prior to July 8th that I've reviewed.
So you can't represent to this jury that there's anything in any report, any conversations between Jay Lee and Jimmie Herrington where Jimmie Herrington had coached Jay Lee over to his apartment before, threatened him in any way, or anything like that, can you?
On July 8th.
July 8th, before July 8th, you haven't reviewed any of the text messages or conversations before July the 8th.
No, sir.
And on July the 8th, you represented that you had read all those text messages, Instagram. Is that in a report that was provided to you, but are you actually reviewed the return on the search warrants? Which one is it, Chief?
I've seen some of the Snapchat logs and then our reports.
And do you see anything in there that Jay Lee had threatened my client, that he was going to quote unquote out him at all?
At 4:36, Jay Lee states, I just wanted to say, which is outing, that I had you on the DL again, which is the download. Fun to have been your first guy experience. Jay Lee says, I wanted to say. He wanted to out him.
He wanted to out him? Is that what you say that means?
He says, I just wanted to say. Say is a verbal word.
But your indication is, your testimony here today is that that's an indication that Jay Lee was going to out Jimmie Herrington.
It says, I wanted to say it. He wanted to say that Tim was on the download.
Say it to other people?
Just says say it.
Okay. Do you have any indications from any reports from any officers, whether it be Detective Baker or anyone else, that there's anything in their investigation that revealed that there had been any outing conversations between Jay Lee and Jimmie Herrington prior to July the 8th?
Nothing prior to July the 8th.
Do you have any, have you reviewed any of the other social media platforms from Mr. Lee's Snapchat account?
Snapchat's one account, one platform.
Excuse me, Jay Lee's other accounts other than Snapchat.
I've looked at a lot of messages, so I don't know what all, if they were Googles or, I've just seen kind of a series.
Okay. Do you find anything in those Snapchat accounts that is consistent with the same type of conversations that you have in the July 8th Snapchat conversations between Jay Lee and Timmy Herrington? Late at night, things of that nature, and going over to other people's residence unannounced, things of that nature.
Did we find that in other, I'm not sure, I didn't go through his
You
account.
don't recall?
I didn't go through his account past July the 8th, or prior to July the 8th.
I want to hand you what you marked. Did you review all the way back to June the 14th pertaining to Jay Lee's Snapchat account with Mr. Fears? Have you looked at those?
No, sir, never seen that.
Never looked at it?
No, sir.
All right, thanks. Before we go. That's all I have.
7:23, y'all have passed over the rest here. You may read your, y'all good? All right.
You were asked on cross-examination about the message from Jay Lee to Tim Herrington. I just wanted to say I had you again on the download. What did Jay Lee do after that comment was made?
He responds one more time and says, I've nutted in your floor, so you should clean that up, by the way, and and the nude was fake. Okay, back to block now.
All right, back to block now. So, was there any actions based on the records that Tim Herrington took that would indicate how Tim Herrington understood the message from Jay Lee? I wanted to say I had you on the download.
Can you reframe that question?
Based on that, what happened after that? Can you make any observations on how Tim Herrington understood what Jay Lee was saying as far as outing him to other people?
When Jay Lee makes that statement, then Tim gets a notification that he's been blocked on Instagram. Jay Lee then receives a Snapchat from this alternate account, Red Eye 24. There was kind of an immediate prompting at that point.
And who's trying to reinitiate contact in this?
Tim Herrington.
Okay. That's all I have now.
All right, who would the state call as the next witness?
John, at this time, stay with us.
All right. Y'all approach 1 second. Gentlemen, Jerry, you've heard from the state that they've pressed on their case in chief, so you've heard the testimony that the state has offered. There's some things that the court has to do at this point. I'm going to give you a long lunch today until 1:30. When we get back at 1:30, the state will finish as likely to call witnesses as likely and will not call witnesses, whichever one it wants to do, okay? All right? Remember the course instructions, don't talk about the case, don't allow anyone to talk about the case with you, don't form or express any opinions, don't investigate the case, steer clear of any media reports on this matter, and have a good lunch. Is this witness finally excused? Oh, that's right. Okay, you, Chief, you can't be in the courtroom just that. Y'all have information, y'all get him back if you need him, right?
Yes, sir.
All right, go back to work.
Thank you.
All right. Y'all, state has rested its case in chief, and I understand that the defense has a motion that would like to be heard at this time.
Your Honor.
Yes, sir.
Have we identified all the exhibits that have been identified but not admitted, Your Honor?
We have, and me and Dana's lists are consistent with each other.
Okay.
If anybody wants to look at the list, y'all welcome to do so.
Thank you, Your Honor. May I proceed, Your Honor?
You may.
As to the motion for directed verdict, the state defendant on behalf, counsel for the defendant moves for directed verdict and for the court to discharge him, and in support of it provide the following. First of all, Your Honor, the state has charged a crime of capital murder, kidnapping. This court knows kidnapping has two basic components. Either there's some type of asportation that someone is taken and they move without their will, or the second part is whether or not someone is inveigled, and that is basically under case law, and I think in the statute, a luring, trickery, or a threat, proof along those lines. So it's clear that the state has not placed in the record any proof whatsoever for the jury to consider that Mr. Lee was held against his will and transported, or there's no proof of asportation of Mr. Lee to any other location. So that puts us down to the embezzlement. There's no evidence whatsoever there was any trick associated, or they haven't advanced any proof that there was any trick associated with any conduct on part of Mr. Herrington, whereby he was tricked into coming to a location where Mr. Herrington was and kidnapped and held against his will at that time. Second, Your Honor, as to the threat, it's clear in the record that all the witnesses for the state, investigated witnesses, Chief, as well as Baker and Fortner, none of those three witnesses advanced any proof whatsoever that he was threatened in any way, or there was a threat placed against Mr. Lee that something was going to happen to somebody else if he failed to come to the location where Mr. Lee was. Now we're down to the last aspect of embezzlement, which is the luring aspect, Your Honor. Basically what we've heard in the courtroom today is a summary or an interpretation of one statement, subject to multiple interpretations, as testified to by Detective Baker. In his own testimony, Your Honor, he stated it's open for anybody's interpretation as to exactly what they were talking about. That's what Detective Baker testified to. The Chief testified that basically one word in the statement pertaining to what was going to occur before he was going to go back to block is the evidence of embezzlement, that there was a luring based on that particular statement. Your Honor, the evidence does not support that beyond a reasonable doubt that a jury could find that there was any luring by my client if you take the state's testimony most favorable to the state and give them the benefit of any and all evidence most favorable to the state. Additional argument as to the motion for directed verdict, Your Honor, pertains to the quality of the evidence that was placed into the record. The notice was filed on 11/5/24 pertaining to the 902.11c objections. The notice was filed, the objections were filed on 11/19/24. Your Honor, within that time frame, the court knows certain things were supposed to happen. The state at that time was required by law and required by the rule and the case law that they were supposed to set this matter for hearing, and the court was to rule on whether or not the objections were valid and whether or not the evidence that was in the notice would be admitted into evidence. The only piece of evidence that the state should be able to advance as to the 902.11c would have been one video. If the court had granted the state's objections based on the rule of court. And I'll state exactly how it goes, Your Honor. An adverse party waives any objection that is not specifically stated in writing, which we did, served within 15 days after receiving the notice required under paragraph B, or at a later time that the party has agreed on. That did not occur. The proponent must schedule a hearing on any objections, and the court should determine the admissibility of the record before the trial or hearing at which it may be offered. If the court cannot do so, the record is not self-authenticating under this particular paragraph. The court made a ruling, Your Honor, that basically two things occurred. The court made a determination that there was sufficient indicia of reliability for these particular documents, Your Honor. That is not in the rule. That is not the mechanism by which the rule authorizes the introduction of these particular documents. The court also made a determination on the record that the court was familiar with the locations within Lafayette County, and that due to that, part of the ruling included, due to the fact the court was familiar with those particular locations, certain pieces of evidence that included videos of Jay Lee's car traveling throughout Lafayette County in different places and showing Jay Lee leaving his apartment, things of that nature were allowed into evidence. Your Honor, the defendant respectfully submits to the court that that was error and that those matters should have been excluded, and at the conclusion now where we are of the state's evidence, that there was not sufficient evidence, value of the evidence is not sufficient for this case to go forward on murder, capital murder, or any other charge, Your Honor. Now, getting to the last argument. The defendant filed a motion to dismiss this case on a defective indictment. Document 98. 12/2 of this year in chambers before voir dire. A hearing was had wherein the court, without advancement by the state, ordered that the indictment be amended. To this date, Your Honor, that indictment has not been amended by any order, not on the file, and the state's rested. There's no order amending this indictment, although unprompted by motion, there was an order that the indictment should be amended. Unfortunately for the state, they've rested without an order being on file amending the indictment. We move forward on a defective indictment. The state has closed their evidence, and directed verdict should be advanced. Our motion for directed verdict should be granted based on the procedure that's taking place in this file, Your Honor. I checked a few moments ago. I had Mr. Dagnall check. No order's been entered amending the indictment, and therefore, that part, in addition to all the other portions of the motion for directed verdict, taken as a whole, quality and quantity of the evidence presented here today, the fact that the order amending the indictment has not been placed in the court file signed by the court, in addition to the fact that the state has failed to make a prima facie showing that a jury should consider the luring aspect of the embezzlement. And additionally, Your Honor, if you recall the testimony of Chief McCutchen, he said that there was a time frame of 6 o'clock to 7:28, time frame by which he anticipated that Mr. J. Lee, between that time, died. There's absolutely no proof of a death. The element of luring is insufficient as presented to the jury. The 902.11d requirements were not followed, and the introduction of those tapes should be stricken at this time, removed from the record, and furthermore, Your Honor, no amendment to the indictment has been placed in the file. Hence, we went forth on a defective indictment, and this matter should be dismissed by motion, granting the motion for directed verdict.
All right, anything else?
That's all.
All right, I'll hear from the state.
I will start in reference to the indictment. I sent the amended indictment to the email address bhartfield at forestcounty.ms.us shortly before voir dire as directed to by the court. It was emailed at 9:55 a.m. Apologize. I sent the when we were in Hattiesburg, Your Honor stated that we needed to get the indictment on file before we started voir dire. I sent an email to the email address bhartfield at co.forestcounty. I believe that's Brooks' email. Is that your email? bhartfield. Oh, I was instructed to send it. He told me to email it to bhartfield, and that's what I did. I emailed it to bhartfield, as well as CCing Mr. Creekmore and Mr. Haran. So while there, that's what I did, as instructed. I did assume that it was printed out. I wasn't sure whose email that was, but I was told to send to bhartfield at forestcounty.com. So that's what I did. So I'll address that first. The amendment was completed and it was sent at on 12/2/2024 at 9:55 a.m. Before we started to select the jury. Now, I assumed it was printed out and given to the court and all of that, as that was what was told to me to do. As to the argument to the actual elements of the crime, as the court is aware, the standard for directed verdict is to take the evidence in the light most favorable to the state. There's been ample testimony that this all happened on July 8th, 2022. Jurisdiction has been testified to by, I believe, Shane Fortner, and a witness today, I believe, Chief McCutchen. He also testified to it. As to the element of death, we of course had to prove that Jay Lee was a human being and that he was no longer alive. The court heard testimony from Jay Lee's mother, who testified that he called her every day, he spoke every day. His friends, two at least, Khalid Fears and Jose Reyes, who testified that they hadn't seen or heard from him since that day in July, or for Jose, since July 7th, 2024, that he hadn't appeared on social media, that he regularly engaged in social media, possibly posted on social media every single day. We've heard testimony that his dog, whom he was very close to, was abandoned, that he would take photo shoots with his dog, that he would take the dog everywhere with him, even to class. He wanted to take it to class, that the dog was abandoned. We heard testimony from officers regarding his financial accounts and his mother, that to this day those accounts remain untouched, that the last transactions that happened on those accounts was July 8th or July 7th, 2020, Two, besides some accounts that had automatic charges that could happen without him, we heard testimony that there was no evidence that he had suicidal tendencies, that he was depressed, that he was unlike him to disappear on his own. Further, his ID, all his credit cards, his driver's license, things that he would need to be out into the world were all found within his vehicle on at Molly Bar Trails, which was parked there at 7/8, the same day he disappeared, and towed the same day he disappeared. We heard evidence that his apartment remained unpacked. All his possessions were still there. Nothing was taken or removed. Your Honor, we provided sufficient evidence to where a reasonable juror could determine that Jay Lee was no longer alive. Maybe I should forward it. As to the element of kidnapping, Your Honor, opposing counsel defined there's 3 types of kidnapping. That's what the case law says. The theory by which the state proceeded under was a theory of inveiglement. Now, inveiglement specifically means to lure or entice through deceit or insincerity. And there's no component of force, and you cannot forcibly inveigle, which is why the state was confused regarding all of the force talk. It is to essentially lure or convince someone to come to you by being insincere, through trickery, or through deceit. In this case, Your Honor, the text conversation between Jay Lee and Timothy Herrington is very important. It actually starts off where we know that Jay Lee has left Timothy Herrington's apartment upset. We know that based on Timothy Herrington's recorded interview, where he stated that Jay Lee was mad when he left. We know that because Jay Lee blocked Timothy Herrington after he left, and people don't usually block people that they want to continue to communicate with. We also know that Jay Lee said something that could be perceived as mean to him, talking about how I nutted on your floor back to block. Following that, Jay Lee is communicated on an account that he doesn't recognize. We know he doesn't recognize because he says, "Who the F is this?" Then Timothy Herrington re-engaged Jay Lee. His first message to him was "come back." But before he stated that, Your Honor, he calls him 3 times unanswered. Then there is one answered phone call through Snapchat for 14 seconds. Then the conversation then continues between the two. And at this point, we realize that Jay Lee knows that it's Timothy Herrington because they pick up their conversation back from when he was blocked. Your Honor, at this point, he asks, "Come back." Jay Lee says, "No." He says no. Tim Herrington continues to speak to him. Jay Lee responds with why he won't come back, again, indicating that he wasn't going to come over. And it's important what he said, because it wasn't just that Tim Herrington wouldn't perform oral sex on Jay Lee. In that message, Jay Lee describes having been treated poorly by Tim Herrington. He says not only that he didn't reciprocate, but also he insulted Jay Lee by telling him to stop harassing him and telling him that they would stop linking, as in meeting up for sex. And this was immediately following their sexual encounter. That's why Jay Lee was upset, and it's laid out in that message. And then, Your Honor, he tells him he's gone too far. Jay Lee says to Tim, "You've gone too far," and says good night. Again, Tim Herrington says that he doesn't want it to end like this. He tells Jay Lee he's a cool person. Jay Lee then says that his one condition to come back was if Tim would agree to give him oral sex. Now, per Tim's own interview, Tim Herrington's own statements, he invited Jay Lee back over to make it up to him. That's Tim Herrington's statements. Tim Herrington says Jay Lee was mad. Tim Herrington says he had to invite him back over and promise to make up to him. But what's really interesting, Your Honor, and what goes to the deceit, trickery, or luring is that Tim Herrington also says in his interview that he never does that. He never performs oral sex on men. He says that he's never done it before. He says that Jay Lee usually comes over, but this time he's promising to do something he's never done before, which is what he says in his interview. That also came from Khalid Fears, that Jay Lee was going to do something sexually that had never happened to him before. Tim Herrington in his interview, after saying that he's going to do something he's never done before, when you think about that, Your Honor, the evidence in context of what's happened, Jay Lee had just left this man's apartment. This man had just told him, stop texting me, had just told him, I don't want to see you anymore. Then, after Jay Lee says, I just wanted to be able to say, I had you be DL, and blocks him, suddenly, Tim Herrington is calling him over and over again, texting him over and over again, asking him to come over to do something that Tim Herrington didn't want to do because he never did it before. Further, as proof that he never wanted to do it, Your Honor, Jay Lee brings up, well, I'll come, but, I'm gonna have to get this in the front. And Tim Herrington, he just says, in the text message. Then Jay Lee doesn't even know what that means. He says, okay, I'll do it. Because he never intended for Jay Lee to come over there for oral sex. The evidence could be perceived that way, Your Honor, and that's how the state reads it. It's very obvious. He never intended him to come over for sex. And then further evidence by that, and that he wasn't enthusiastic to do it, is that immediately following Jay Lee's agreement to come over, Tim Herrington Google searches, how long does it take to strangle someone? Your Honor, even Jay Lee in the text was confused by Tim's repeated calling and texting and asking him to come over because he says, why are you doing this? It's like you're trying to lure me, because that was not the tenor of their relationship, and that's very clear from the text message. And a jury that heard that could reasonably infer that. Your Honor, Tim Herrington, when you look at the evidence in whole, the conversation in totality, in combination with his interview, it's very clear that Tim Herrington didn't care about Jay Lee. When he asked him to come over, it wasn't because he wanted to be on good terms by doing something he never wanted to do in the first place. That was the insincerity, and that was the trick, that was the deceit. As we further move on in considering the theory of inveiglement, Your Honor, I would cite to the Moberg case, 303 Southern 3rd 815. I believe opposing counsel said as to kidnapping, he had to have the intent to keep him or snatch him. No, Your Honor, if the court looks to Moberg, in that case, they talk about how kidnapping is not a specific intent crime. The significance of the...
There's an inveigling case decided a couple of years ago. Was that it?
No, this is actually newer, Your Honor. I believe this is from 2024.
2024. I knew the one very recently. I probably it anyway.
Your Honor, they say the significance of the holding that no specific intent is needed is that the defendant need only to have the intent to cause the events that followed. In that case, all that happened was the defendant, Moberg, was upset that the victim had slept with his girlfriend. He told the victim, we're cool. Then he went over to the victim's house and he asked him to come help him with stuff. He asked him if he would help him move. Then the victim and the defendant drove from, I think it was Alabama, to Mississippi because the victim voluntarily agreed to help him move. The victim was then killed in in Mississippi. Eventually, his body was found, although no cause of death could be determined. Moberg appealed and said that there was no evidence of kidnapping. But as here, the victim voluntarily got into the defendant's truck under the guise that he was going to help the defendant move. Jay Lee did voluntarily go to Timothy Herrington's apartment, but of course it was under the guise that Tim Herrington was going to perform oral sex on him. But again, Your Honor, the evidence put forth is that, one, Tim Herrington has never done that before. Two, he didn't want to do it earlier in the night, so much so that he told Jay Lee, let's stop linking and stop harassing me. And three, that Tim Herrington only suddenly became interested in having Jay Lee come back over after Jay Lee blocked him and made the statement, I just wanted to be able to say, I had you BDL. And I would further state, Your Honor, that per the evidence provided, a reasonable juror could reach the conclusion that Tim Herrington, following Jay Lee coming over to his apartment, and that 7:28 time was important because that's when Jay Lee's phone completely cuts off, never comes back, that Tim Herrington is then seen taking this fantastical run that he describes in his interview, somehow getting into Molly Bar Trails without ever running into it, right after Jay Lee's car is parked at Molly Bar Trails. So I put forth, Your Honor, that the state has, in fact, put forth a prima facie case of death, kidnapping, and altogether capital murder. As to the indictment, Your Honor, I did what was directed to me.
The issues on the self-authentication issues, or let the court handle them on his own?
Well, Your Honor, the court already ruled. I believe that ruling, I don't believe that that was the proper place for, or the proper subject of direct verdict argument. The court has ruled there was sufficient indicia of reliability for those documents. It is not true that the only one tape would have come in. The campus walk videos, Your Honor, are from UPD testified to those. The campus walk, the campus videos, that's from the university. University police is in charge of the university. Those came in through the university. To the Renaissance Bank videos, the Renaissance Bank woman was here. The videos from the cleaner woman was here for that. Mr. Klink was here for the videos from his home. We called the witnesses. The other videos, Your Honor, was the Walmart video. The Walmart representative was here. So, Your Honor, that's not true that only one of these videos would have come in. The witnesses were here to authenticate them.
All right, I'll give you one beat for rebuttal.
Your Honor, first of all, the case that she cited involving the inveiglement, there was clear evidence, as I understand the case she cited, Mr. Dagnall and I discussing, there was evidence of the exact purpose of the representation about the purpose of the trip, getting that individual over there, which was false. There's nothing in this particular case, Your Honor. Mr. Beers testified that the man was going over there to have some fun. There's no misrepresentation to Mr. Lee as to what the intent was when they were coming over there. There's one, according to their state's witnesses, Your Honor, there's one and only one witness testified, that chief, who wasn't involved in the investigation, basically made reference to, I just wanted to be able to say, I had you be the DL again. Subject to multiple interpretations. How in the world are we going to move forward on an inveiglement case when the state has presented their proof that that is the evidence of inveiglement, Your Honor, during the course of the conversations between
these two individuals. I can't imagine moving forward with that scant amount of evidence, going forward with the capital murder case where Chief McCutchen said that he couldn't present any evidence previous to the 8th day that they'd had any conversations that supported that my client had lured him over there, that had any other arguments or anything like that, Your Honor. The second thing on the 902, the only tape that would have come in would have been the body cam. The argument is that the procedure that was followed, Your Honor, was an improper procedure. That evidence, I know the court's ruled on it.
On those done at Grenada, I think I don't think the rule doesn't require that there not be self-authentic, that you can't put them in. It just means you have to bring authentication, right?
No, Clint could testify, Your Honor, but what evidence at the time without the other videos show any crime? What evidence without the other videos and the Oxford videos showing a boxcar going down the road supports a conviction? If the court went back in chambers and said, you know what, I probably didn't do it right on that 902.
I'm not.
I know you're not.
No.
But my point being, and I no disrespect to the court, but there's nothing in that rule that talks about indicia of reliability. It's not in there, Your Honor.
All right, I'm ready. Unless you got anything else? I don't mean to cut you
Can't
off.
think of anything else.
All right.
But
All right, I'm going to make, I'm this time.
now, hold on, Judge. One more thing about this order on this indictment.
Okay.
I hope we're not going down that path today on the capital murder case that you can email an order, amend an indictment somewhere, and stay here 9 days and not get it filed and signed by the court before the close of the state's case. Or even the start of the case, to be honest with you. I hope we're not going down that path, Your Honor. Thank you.
Here we go. As to the self-authentication matters of videos, the court thinks it got it right. And I think we've made a record on this before, but I'll go back and sort of recap that. The state filed its notice of self-authentication. The defense filed a response, and our court files it within a required time. You filed it within the required time. The state indicated that they did not get that notice, that the defense was objecting until it was brought to their attention on Monday, was 2 weeks ago when we was having court in Ripley. We talked about this in chambers. That was Monday before Thanksgiving. Court said we'll deal with it when we can have time. The court took it as we were having a hearing on it. As to those videos that the court was found were all here in Oxford, Mississippi, on a short route, all in close proximity in time, all in a route known to the court. Court found that those I was going to, if I had a formal hearing on the record, I would have allowed those documents to be self-authenticating. Time didn't permit it. From the time the state, a formal hearing, from the time the state found out that there had been an objection to the current time. If the court is wrong on that, I think there's still sufficient evidence and other means of this court that phone records, Snapchat records, records from Walmart, that there was self-authenticating, that there was authentication made, police department, university cameras and things like that, that the case could have survived a motion to direct a verdict, even if the court is was to be deemed wrong about that. As to the sufficiency of the evidence, I think the state has set forth a prima facie case that Mr. Herrington was alive, that he is no longer alive. There's a prima facie case that he came to his death at the hands of Mr. Herrington. The jury could see it that way. The good jury could see it another way. They made a prima facie case. They've also made a prima facie case that occurred in Lafayette County on July the 8th, and they've made a prima facie case based on the text messages, that I call them, communications between these two parties, that there could have been luring in this case. Don't know that that'll be for the jury to decide, but they've made a prima facie case. As to the issue of amendment of the indictment, the court on the record ordered that the indictment be amended, that court found that the statute required the code section of the underlying crime in a capital murder case be included in the indictment. The court further found that there's only one code section for kidnapping in the indictment, that there's no surprise to the defense. It can no way could change or affect the defense in this matter, with the fact that those few numbers for the kidnapping section, code section, be included in the indictment. Kidnapping is kidnapping is kidnapping in Mississippi. There's no different statutes for kidnapping. The court allowed the indictment to be amended to include the code section number for the kidnapping. I ordered that the indictment be amended. This court has no knowledge other than what's been reported to the court this morning, that it was emailed. We were in Hattiesburg, picking a jury for this case. The state indicated when and where they emailed it to, and I'm going to deny your motion for directed verdict in this case. You can make any further record you like.
Your Honor, I think I need to clear up that the order failing to amend the indictment, the motion for directed verdict would be that the court should grant it. Alternatively, would be that due to the fact that the indictment wasn't amended, that it would move forward to the jury on, since the kidnapping aspect would not be viable, it would go to the jury on murder, as opposed to if the court found the prima facie showing had been made.
I'll ask for the state to make a response to that. They may be willing to confess that anyway. I don't know. The court is not going to, if the state wishes to move forward without the kidnapping, I'll allow them to, but if they don't, I'm going to play the cards we got, okay? That I'm going to. All right? Let the parties both know what you've uncovered there anyway. apparently the, I'm not gonna make any comment on that on the record. If anybody else wants to, they can, okay?
Your Honor, based on what, been provided, my understanding of consent is not anything close to an order amending the indictment and not
I
signing.
will say for the record, I have not signed an order amending the indictment. I have made a pronouncement from the bench that, so the record's clear, I have not signed an order amending the indictment. I have pronounced from the bench that the indictment would be amended for the record. That's where we stand anyway, okay?
I understand.
All right. It's 12:30. We got another hour, and we will, unless there's something else, will the state, you think the defense be ready to move forward? I would like to cover this right now in case I forget it later. Mr. Herrington, I'm going to direct this line of thoughts to you personally, not necessarily to your attorneys. The state has rested its case. You have the right to put forth testimony in your defense. You have the right not to. You have the right to testify in your own defense, or you have the right not to. If you choose to testify, you'll be subject to cross-examination by the state. If you choose not to testify, the jury will be instructed that the fact that you did not testify could not be used as any evidence of that you were guilty of any crimes. The decision whether you wish to testify or not to testify is your decision. It's not the decision of your attorney. I encourage you to consult with them. They've been in this game a long time and know what they're doing. But ultimately, the decision to testify or not to testify will be your decision. I'm not going to ask you what that decision is at this time, but at some point before the trial is over, assuming you're putting forth other witnesses, which I understand you are, but even then, when you've called any other witnesses, I want you to be prepared to tell the court whether you wish to testify or not to testify, okay? All right? All right. Court's going to be in recess until 1:30. If y'all think of anything else we need to cover before then, I'll be around so that we can do that, so the jury be ready to go at 1:30. right, hope everyone had a good month and had no problem with the court instructions. This time the state has rested, you've heard the testimony from the state, and now the defense will have an opportunity to call witnesses, in this case the chief anyway. My daughter yesterday told me, so I look like Nick Saban up here, my Coca-Cola can up here, my product endorsement, so I'm swapped the Taylor grocery today. Alright. Who would you call as the defense's first witnesses?
They would call Laura Reed, R-E-I-D.
Walter?
Laura Reed.
Alright.
And I would just like to state for the record that this name was not revealed during voir dire.
Alright, that'll be noted for the record. We'll see if it becomes relevant.
She was provided in discovery, Your Honor.
Okay. All right, have a seat in the witness chair, please, ma'am.
Wait till we get the mic going, Judge.
Yes, that's right. We can take them off earlier. There's somebody.
Your Honor, while we're waiting, I've got D-108 to introducing the evidence. Not going to be used with this witness, but I don't think the state has
Go
to
ahead,
check.
Mark, deal 108 if you want to. I think I heard wrong. Your name's not Walter, is it? Laura. I told him I left my hearing aid at home today.
I could have done that.
We're gonna give you a bonus, Mr. Clerk. I mean, you're fixing their windows for us and then microphones. I believe it's working. You may proceed.
Thank you. Please state your name for the record, if you would.
Laura Reed
Ms. Reed, where do you live?
in Grenada,
What's your address?
160 Shadowwood Cove.
I want to direct your attention to on or about the July 7th, 2022. Did you have an occasion to have a conversation with Timmy Herrington pertaining to a move that would occur for you?
Yes, I did.
All right. And do you recall the substance of that conversation you had with Mr. Herrington?
I texted him. He had moved some furniture for me before, and I texted to see if he was available to move some furniture from Batesville to Grenada and some other furniture from Grenada to Batesville, so a round trip.
Now, it's a round trip. Do you know what your plan was as far as making that particular move? Had you solidified your plans on the 7th of July?
Yes, I texted him that Thursday the 7th and asked if he was available. I think he first offered maybe a later date. I asked for an earlier date. He said Monday the 11th, and I said that was great.
Okay. Did you understand that? Did you have any other conversations with Timmy about the move after the 7th, either by phone or by text?
Yes, so we texted on Thursday the 7th. On Sunday, which would have been the 10th, I confirmed with him and asked if he wanted to start in Grenada or Batesville, since we would, be going both places. He said Grenada and Monday morning at 8:30.
Okay. And at the time you had that conversation, that was the first time y'all had solidified basically when you would do that move. When did y'all finalize the move when you knew for sure when he was going to do that move?
I guess I thought it was for sure on Thursday, but we actually confirmed it on Sunday.
All right. Give the court the benefit of what transpired as far as that move. Who showed up? Was he by himself? What vehicle he was in? on that particular day?
Timmy showed up. He had his cousin Jordan with him. He had a white moving truck. What else did you ask? They came about 8:30, I think.
When you said they came by 8:30, where did you meet with them?
At my house in Grenada.
Okay, where did you go when you left? After y'all met in Grenada, where did y'all go?
I went in my car. He and Jordan were in the truck, and we went to Batesville, and we made a stop at a storage unit, got a rocking chair, a few things there. We went to my in-laws' house in Batesville. In Grenada, we took the bed apart from my house, put it on the truck, went to Batesville, took her bed apart, swapped them out, and then came back.
Okay, when you say you took the bed apart, did you do that or did Timmy and Jordan do that?
Timmy and Jordan did it.
And they took it apart, did they pack it, put it together, package it up? What happened pertaining to that?
Both of the beds had a lot of parts, and so I think I recall Timmy put the screws in smaller pieces in a Ziploc bag and taped it to the rails for the bed at my house, and then the same thing for the bed at my in-laws' house.
You know exactly what type of tape he used to tape those items?
I don't.
Did you at any time help him pack anything or do anything? He just moved everything. Basically, that was his job. Is that right?
I think he did it all.
And it was him and Jordan together, right? He and Jordan.
Correct.
After you did that packing on that date, and what happened then when y'all at Grenada? Y'all went from Grenada to Batesville, right?
Went from Grenada to Batesville, put the Grenada stuff in the Batesville house, got the Batesville stuff, brought it to Grenada, and then he set the bed up in my Grenada house.
Okay. What items did you pack in Batesville, out of the Batesville location to bring back to Grenada?
It was one of those beds, where the one side will raise and the other, and it has the cords and all of that. We took that. We took, a rocking chair, several other items, but I can't recall exactly what they were.
How many times have you used Timmy to help you move items?
He has moved stuff for me twice, and then another time he came to an apartment where some furniture had been delivered, and he moved it up the stairs.
What location was that?
That was my son's apartment in Oxford.
And do you remember about when that time frame was?
I want to say that was February.
February of the same year, 2022?
All of the moves were in 2022.
And same procedure took place where basically Timmy did everything, taking the beds down, moving boxes, stuff like that. He did all that. You basically stayed out of the way. Fair statement?
Well, there was one time we were trying to move a couch up the stairs or down the stairs, something, and I think I helped. But yeah, Timmy handles it all.
All right. Now, as far as you live in close proximity to the Herringtons, correct?
We live on the same street, probably 3 houses apart, but across the street.
How long have y'all lived across from each other or down the street from each other?
15 years, I think.
Now, Ms. Reed, have you ever seen activity in the front yard of the Herringtons as far as yard work or equipment out there, things of that nature, loading stuff?
Objection to reading.
I'll rephrase your question. Give the court and the jury the benefit of your observations as to activity in the front yard that you've seen pertaining to Timmy Herrington, work-related.
My house is past their house, so anytime I go home, I drive past their house, and their family has, I think, what appears to be a yard maintenance business. There will be trailers with stuff. They have a charter bus business, so there's sometimes stuff with that. Their church, I know they have a big music thing that they do with their church. So there's often trucks and equipment and lawn stuff.
The box truck that Timmy used on the move in July 12, 2022, prior to that date, had you seen it on occasions at the Herrington residence?
Yes.
How would you classify that, regular or otherwise, on a regular basis?
I mean, I haven't committed it to memory, but I would say it wouldn't be unusual.
To see it there?
Right.
Would it normally be parked? Where would it normally be parked?
I guess it would depend on how many cars were in the.
Have you seen it parked in any location in front of the house?
Yes.
Portland does.
Good afternoon, Ms. Reed. Just so I'm clear, the move that you're referring to, you set it up with him on the with Timothy Herrington on the 7th
Yes.
of 2022. Okay. And then the actual move took place on July 11th, 2022.
Yes.
Okay. Are you aware of what Timothy Herrington was doing on July 8th, 2022?
No.
Okay. Do you have any knowledge regarding Jay Lee or anything of that nature?
No, ma'am.
Are you aware of if, you said you lived by them for 15 years, correct?
Approximately.
Okay, and in those 15 years, have you seen their children and interacted with the Harringtons and their kids often?
Yes.
Okay. Are you aware of if Timothy Herrington ever had any boyfriends?
I'm not aware of any.
Are you aware if Timothy Herrington is gay?
I'm not aware.
Okay. No further questions.
No.
All right, next will be fine excused.
She made it.
Thank you for being here, Ms. Reed. You're free to go. You're welcome to go, whatever you like. All right, everybody good on the jury? If so, who you call as your next witness?
Judge, the defense of the next call, Mr. Quentin Love.
Quentin Love?
Quentin Love.
Somebody show Quentin Love. There. You may proceed when ready, Mr. Dagnall.
Thank you, Judge. Could you please state your name for the record?
Jeremiah Love.
And Jeremiah, is that your full name?
Quentin Jeremiah Love, my full name.
And you prefer to go by Jeremiah?
Yes, sir.
Is that all right if I call you Jeremiah here today?
Yes, sir.
So, Jeremiah, would you please, without giving your address, tell the court where you live?
Grenada, Mississippi.
And Jeremiah, how long have you known Timmy Herrington?
All my life.
And from what basis have you known him your entire life?
Since we grew up together.
Do y'all have any relationship together? Are y'all related?
Yes.
And what is your familial connection? What is the family relationship?
My grandmother and his grandmother are sisters.
I'm sorry?
My grandmother and his grandmother are sisters.
Okay. So, Mr. Love, during your time knowing Mr. Herrington, have you ever been involved in his moving company?
Yes.
What did you do in connection with his moving company?
Basically helping move all big stuff, basically all that, move all big stuff.
Okay, so you would assist him in some of the moves that he did with his moving company?
Yes.
How would, 'cause I understand, did he have a business partner in that moving company?
No.
He didn't have anybody else that was involved in his moving company?
No.
Okay. So how would he contact you and let you know that he needed help on a move?
You know, call. Either you call or you text me.
Okay, and what would the gist of that conversation be?
He'll normally ask me if I'm busy, don't want to help him move stuff. I'm like, I help my mom.
Okay. Did he call you every single time he had a move, or just when he needed extra help?
Just when he needed extra help.
And primarily, what areas would he call and ask for you to assist him?
Basically in Grenada.
Okay. Did you ever assist in moves anywhere else, or just in the Grenada area?
I helped him one time in Oxford and from Jackson to Texas.
Okay. So one time in Oxford, you said once from Jackson to Texas. Beyond that, the majority of the time that you assisted was in Grenada?
Yes.
Did Timmy ever contact you requesting help or assistance in doing any other types of work aside from moving business work?
Yes. He granddaddy got rental property. I always help him cut around, cut grass and stuff.
Can you speak a little bit slower and try to just enunciate a little bit?
Oh, my bad.
So, what other work would Mr. Herrington request your assistance in?
With granddaddy have rental properties, so I always help him cut grass.
His granddaddy had rental properties?
Yes.
Do you know, in general, where some of those properties were located in Grenada?
Yes.
And so where would that be?
Basically in town. You got some on Pecan, Carpenter Road. Basically got houses like everywhere in town.
Does he have some houses in town?
Yes.
Does he have some houses north of town?
Yes.
Does he have some houses south of town?
Yes.
Objection to leading, Your Honor.
So, Mr. Love, what types of work would y'all be involved in doing in relationship to these rental properties?
Cutting grass or picking up trash.
Was there any other general maintenance that was done in these properties?
Cleaning out the rental houses too.
Okay. And were you around when Mr. Herrington would be told to do this work, or was this communication he would have had with Mr. Herrington beforehand?
Communication.
When you guys would be involved in doing some of the moving business, what vehicle did you normally use to do the moves?
His box truck.
Is that a white box truck?
Yes.
Did you ever use any other vehicles in relation to the moves, or was it just the box truck?
We use some of his granddaddy got handicap vans, so we use some of his handicap vans.
Would that be for smaller moves, or was that?
Yes, small moves.
So anytime you had a large move, you needed to use the box truck?
Yes, sir.
Did it ever come to your attention that Mr. Herrington would use the box truck for other reasons aside from just using it during moves?
Yes.
And what types of things was he using the box truck for aside from moves?
On here are like little dirt rides in there, so we always have a broom on the back of the box truck, and we always sweep it off before we have to do our next move.
Okay. Could you repeat just the first part of that?
I said, he always had like little dirt rides in there, so we all have a broom on the back of the box truck. We always sweep it off before we all make our next move to go do movement.
Okay. You said that there would be dirt in the back of the box truck, and you would have to use a broom to sweep it out?
Yes.
And what did that mean to you when you would have to clean out dirt or debris from the back of the box truck?
What do you mean by that?
Well, I asked the question, when he would use the box truck, would he use the box truck for other things?
Oh, yeah.
Your response was that sometimes there would be dirt in there and we would have to use the broom to sweep it out. What did the presence of the dirt in that box truck that you had to sweep out, what did that mean to you?
They did other stuff beside, moving around.
Would you see Mr. Herrington driving the box truck?
Yes.
Would you see him driving the box truck at times when he was not engaged in a move?
No.
So you never saw Mr. Herrington drive the box truck to any other locations?
No, sir.
When was the last time that you remember driving the box truck?
The last time we were moving, it was moving my sister back home from Memphis, Tennessee, back to Grenada.
And when was that in relation to the time that Mr. Herrington got arrested?
I think this was before he got arrested. I'm not really sure what the date was.
Mr. Love, have we previously discussed aspects of your testimony at my office?
Yes.
When we were at my office, I showed you a photograph of a wheelbarrow at that time. Do you recall that?
Yes, sir.
Describe, as soon as I showed you that photo, what did you recognize that photo to be?
The wheelbarrow.
And where did you recognize that wheelbarrow from?
In his daddy's garage.
You're saying when I showed you the photo, you recognized that wheelbarrow as being the same wheelbarrow that came out. You recognized that photo immediately?
Yes, sir.
And I believe you just said, but where was the wheelbarrow that you knew of to be located prior to seeing that photo?
In the garage.
Now I want you to look down here, right here at the stand up if you need to be. You need to. Is this the wheelbarrow that was depicted in that photograph?
Yes, sir.
Is this the wheelbarrow that you remember being in Mr. Herrington's garage?
Yes, sir.
Is this wheelbarrow in essentially and materially the same state and condition as you remember it previously?
Yes, Your Honor, no foundation to when he last saw it, how he last saw it.
I think he's testified sufficiently for that question. You may ask the question.
Mr. Love, is this wheelbarrow in materially and substantially the same state and condition as the last time you saw it?
Yes, sir.
Attend to the witness.
Good afternoon, Mr. Love.
No.
When did you start working with Timothy Herrington at the moving business?
Doing COVID.
So, like 2020, like when COVID first started?
Yes, ma'am.
In 2022, were you working for him or with him? Did he hire you, or were you working together, or was he would hire you to pay him?
Working together.
Sorry. So you were like a hired employee sometimes?
Yes, ma'am.
Okay. And in 2022, you were working?
Yes, ma'am.
Okay. In July 2022, were you working with him?
July
Yes.
22? No, not in July 22.
Okay, so in July 2022, did you ever see him doing moves with the box truck?
No, ma'am.
And you also stated on direct just now that you only ever saw him using the box truck when he was doing moves, right?
In Grenada.
Yes. So you only ever saw, that's in Grenada when you saw him doing moves, in the box truck, he was doing moves. Would that be correct?
Yes, ma'am. Grenada, I'll be with him.
Okay. You said that you've known Timothy your whole life,
Yes,
right?
ma'am.
Y'all grew up together?
Yes, ma'am.
Would you say that y'all were close?
Very close. We're like brothers.
Okay. So in your time knowing Timothy, did he have girlfriends?
No. Yes, ma'am.
Okay. Did he have boyfriends?
No.
Did you know that he liked men?
No.
Did he ever tell you he liked men?
No. I don't judge.
Yeah. I understand you don't judge, but did he ever tell you that he liked men?
No, ma'am.
Okay. And I believe you said that you've seen that wheelbarrow before, right?
Yes, ma'am.
And it was in the garage of
They home.
Mr. Harrington's house?
Yeah, man.
Okay. And have you ever seen Timothy using the wheelbarrow?
We both have.
Okay, so when you used it, it looks like it's clean now. There's no dirt in it. Was there dirt in it when you used it?
When we always use it?
Yeah.
Yes.
Okay. So dump the dirt out, rinse it off, and put it back, right?
And half the time be with like excess grass too. Excess grass. Excess grass, like
Excess
dead
grass.
grass.
I'm sorry.
Yeah.
Okay, and you would rinse that off and put it back
Yeah, man.
to keep it in a nice condition, right?
Yes.
Okay. No further questions.
All right, redirect.
Mr. Love, you would only, would Timmy call you every time he needed help?
Yes, sir.
So were there moves that Mr. Harrington did when he didn't call you?
No. Even grenade wise, no.
Well, I'm saying, you were not a partner of this business, were you?
No, sir.
Okay. So, is it your testimony that you assisted on every single move he did in Grenada?
Yes, sir.
Okay. You said that sometimes there would be dirt or debris in the back of the box truck that you'd have to sweep out. During the course of your moves, was it common to track a bunch of mud and debris in the car in the back of the box truck during the course of a move?
Yes, sir.
Thank you, Mr. Love. No further questions.
All right, may this witness be found excused? This witness be, you're welcome, you're free to stay, or you're welcome to go, whichever one you like. Thanks for being here. I need to take up another matter, not related to this, just for 1 minute anyway, okay? Come on back. As y'all know, sometimes the world keeps spinning whether we here or not anyway, so that takes care of some other matters. Who would defense call us next witness?
Sheldon Herrington.
Sheldon Harrington.
May I proceed, Your Honor?
You may proceed.
State your name for the record, if you would.
Sheldon Timothy Herrington Sr.
And what is your relationship, if any, to the defendant, Timothy Herrington?
Tim is my son.
Are you married?
I'm married.
What's your wife's name?
Tina Herrington.
You have any children other than Timmy?
Yes,
How many?
I have 4 other children.
What are their names?
Name is Kayla Herrington.
How old is she?
Kayla is 22. She'll be graduating this coming Friday.
Here at Ole Miss?
Nah,
Where?
Delta State.
Delta State. You have any other children?
I do.
All right, tell us who they are.
I have Jeremy Purnell. I also have Ebony and Dominique Brown.
And what are their ages?
Dominique is 32. Ebony is 30. And Jeremy is 25.
How old is Timmy right now?
Timmy, man, he was born in 2000, so he's 24.
And on July the 8th of 2022, Timmy living in Oxford at that time? Was Timmy living in Oxford at that time?
Yes,
And how long had he been living in that apartment, you know, that particular apartment?
that particular apartment, at least I would say a year and a half, maybe 2 years.
Timmy recently, had he graduated recently?
He had recently graduated.
And you know what he got his degree in?
He got his degree in finance.
And during the course of his high school years, college years, did he maintain any type of employment, keep himself busy in any way, shape, form, or fashion, other than schooling?
Yes.
And describe to the jury what that was.
Timmy would go and do work with myself and his grandfather. He would also do going around and helping people move and do different things such as that.
And you stated that he did things for you and your grandfather. Would that be your father?
That would be my father,
What is his name?
James Timothy Herrington.
And you were employed at this time?
Yes, I am.
Where are you employed?
I'm employed with Brentwood Behavioral Health Care of Mississippi out of Jackson.
You got to lean toward the microphone.
Brentwood Behavioral Health Care of Mississippi out of Jackson, Flowood.
And what do you do there?
I'm a counselor.
And as far as you stated that Timmy worked for you and your father, in what capacity? Describe to the jury what type of work he did for both of y'all.
We have rental houses. My father has sets of rental houses, and I also have sets of rental houses.
How many rental houses, if you know, I don't ask you to know exactly how many your father may have, but you have a pretty good idea how many he's got?
Dad has over 50 houses.
And how many do you have?
6.
6. Have you recently purchased any from him or made any purchases on any of his houses?
I've made a purchase on 2 of Dad's houses.
And you know if you do, can you tell the jury when those occurred, those purchases occurred?
Those purchases occurred about 2 years ago on those two.
Those rental houses, are they in the Grenada area?
They are.
Would you describe those two houses in relationship to the other houses in the Grenada area?
Okay. In the Grenada area, my houses that I purchased from him was downtown, going through closer to the courthouse. And the other house that I purchased for him is going to be going towards the school, Grenada School.
Now, you testified just a few moments ago that Timmy would do things for you and your father in rental property. What type of work did he do? What year did he start doing that? How old was he when he started doing that?
Well, Timmy started doing work probably at 8 years old. As much as he could, go and follow us to do housing work. And that consisted of maybe cleaning, manual labor work, mostly. Fixing certain things around the rental property. We will be on top of roofs. We will be in the kitchens, fixing sinks, different other things such as that, but mostly manual labor kind of things.
That include, you said at 8 years old, he wasn't getting on the roof at 8 though, was he?
Well, if he needed to.
So over the course of the years, from the time that he was 8 up until July 22, did he maintain those responsibilities with your father and yourself?
He did.
Okay. Was it a situation where he was under constant supervision, or what? July the 8th of 2022, Timmy's responsibilities with y'all, was it something that y'all had to constantly supervise him, or a situation where that he basically did his own thing?
Same objection. I'll let you answer. Go ahead.
We didn't have to supervise Timmy at all. Basically, if there was something that needed to be done, he would go ahead and do it.
Would you inform him, or your father inform him, that if something needed to be done in a house, he'd go do it, didn't have to have supervision doing that task?
That's correct.
Now, included in those responsibilities, did Timmy have responsibilities at the church?
Yes.
And what's the name of the church that your father was part of in Grenada?
Abundant Life Assembly.
Abundant Life. And where is it located in Grenada?
It's located 88 Cathy Drive. It's right there in the town of Grenada, right off the interstate. Matter of fact, it's the first church that you get to coming into Grenada, coming from the post office.
And could you describe to the court and the jury what those responsibilities would have been there at the church as far as what Timmy would have to do? Did those responsibilities also start early in life?
It did. By me being a musician, Timmy was also a musician. He even taught classes at the church that he orchestrated himself. There were times when he also had to cut grass. We don't have a contractor to do that. Most of the time, I would get Tim and maybe several other young boys rather, to cut the grass, to do certain lawn services and maintenance work around the church.
In addition to those responsibilities around the church and the rental houses, do you likewise do those things at y'all's home?
Yes.
Now, I want to direct your attention to July, round about the time of July the 22nd, 2022. Do you recall the facts and circumstances that gave rise as far as you being notified that Timmy had been arrested?
Yes.
And did you, at any point in time, go or have an occasion to discuss the fact that you may need counsel?
Yes.
With anybody? And who was that?
That was Mr. Horan.
Okay. I don't go into the content of the conversation, but was there an occasion for us to meet at your residence anytime after Timmy's arrest?
No,
Did we ever meet at your residence at all after
Never.
Timmy's arrest?
never.
Did we have conversations about your residence,
Conversation about the residents.
about your house?
Yes.
Okay. And did I give you any particular instructions of what to do as far as your residence and whether or not you need to cooperate with any authorities?
Yes.
Okay. And did you follow those instructions?
Yes, I did.
All right. This wheelbarrow right here, and these shovels, here are these shovels that are in the wheelbarrow. Do you recognize them, Mr. Herrington?
Yes, I do.
Okay, how do you recognize them?
Those are mine.
Now, do you recall the date that a search warrant was executed on your residence?
I do.
You remember what that date was?
That date was, I believe, the 26th of July.
Okay. Had you done anything to alter the character of the shovels or the wheelbarrow or any contents of the house in any way, shape, form, or fashion prior to the time that they executed the search warrant?
No,
You followed my directions?
to the point.
And does it appear that these are materially in the same condition that they were at the time that they executed that search warrant?
Yes.
Were there any other items that were at your home that you've seen a video of that were still at your home now?
Yes.
All right, let's talk about the video. I showed you a video of the UPS Timmy walking across parking lot going to the ATM on the 8th at the bank in Grenada. You saw that today, right?
I did.
Did you recognize the boots that he had on in that video?
I did.
And where are those boots now?
They're still in the same location.
And you followed my instructions as to any physical evidence down at your house. They're still there where they were the day after they left.
Still there.
As far as you cleaning or doing anything to these items that are introduced into evidence, did you do that after we talked on the phone?
No.
Do you recall whether or not between July the 8th and the 22nd, whether or not you had used any of these items in the yard at all?
No.
I'll turn to the witness.
Contamination?
Brief indulgence.
Okay. Good afternoon.
You stated that on direct just now that Tim has been working for you since he was 8 years old.
Exactly.
So doing work, I think you said working on roofs.
Working on roofs, behind the house, in the house, just manual labor work.
Okay. In that work, has he had occasion to dig holes for you?
Occasionally, yeah.
And on July 8th, 2022, I know that we were kind of moving around it. Are you aware of if your son was doing work that day?
No,
So do you know what he was doing that day?
no,
So you're just saying that that's what it wasn't uncommon for him to move around and do work?
no, it was not uncommon for him.
Okay. And you stated that he was, I think y'all's church is Abundant Life,
Correct,
and it's in Grenada?
correct.
Is that a very large church?
The building is, the membership's not,
Okay. And has Timothy been involved in that church since he was a child?
since birth.
Okay. And your church, has Timothy ever brought any girlfriends or anything in relationships to church with him?
Sure,
Okay. Has he ever brought any boyfriends or relationships to church with him?
no,
And were you aware that Timothy had an interest in men?
no.
Today, are you aware that he has an interest in men?
By the proceedings, yes.
And so, back in 2022, were you aware that he had an interest in men?
Other than the reports that came out.
So after the reports came out is when you discovered that?
Yes,
So he was not open with you about that?
no.
Is that something that your church approves of?
Not necessarily the church approves of. I think that with that, people have their own opinions about it.
Brief indulgence. Attended the witness.
Redirect.
Herrington, you were asked about church community there in Grenada. Y'all had, if you had members that had family members that come to your attention, they may have gay members of their family.
Sure,
Objection, leading.
You went into it. You can answer the question.
sure.
Treated them any differently than any
No
other members?
differently.
And also, as far as Timmy, I assume you treated him like a father, like a son or a child, like you did all your other children.
Sure.
Had the same conversations with him about sexuality that you had with others, right?
Same.
Judge him if he would have told you you accepted him still as your son, if he'd told him that he was bisexual, if he'd told you he was bisexual? You still accept him and love him like you did your other children?
Sure.
As far as Timmy's reputation in Grenada for peacefulness, is it good?
Oh, objection, Your Honor. That's outside the scope.
She's out, she opened it up.
I think it's outside the scope.
As far as Timmy's reputation, she asked you about doing things, going to church and things like that. Was he active in the community there in Grenada?
Very active.
Did he have gay friends? Do you know?
I'm not sure if he had gay friends. I'm not sure about that.
Witness him treating gay folks, gay people, or bisexual folks, or
Objection,
anybody?
Your Honor. Outside the scope. I
She
asked
asked
about
about whether or not there was.
I think I'm gonna let you ask.
Did you witness him at any time treat anybody that was that was gay or bisexual or anything along those lines? You ever witness him treat those individuals any different?
No.
No further questions.
Let me, was D-108 ever referenced in any way? You had 108 marked, but it never had been referenced in any way, had it?
Not yet.
Okay, yeah, okay, all right. So you figure. May this witness be finally excused and may return to the courtroom?
You can
You can stay in the courtroom now if you want to, Mr. Herrington. All right,
Can I step out for just a second? You don't have to.
how long we been out here anyway?
So they don't
What
have to.
time? Oh, you can step out for a
Just
second.
1 second.
Everybody good on the hearing? Let me know if you're not. James Herrington, you say? All right, James Herrington, please. Around, have a seat in the witness chair.
Now, Mr. John,
You may.
state your name if you would, please, sir.
James Timothy Herrington,
And what is your relationship, if any, to the defendant, Timothy Herrington?
Miss Grandfather.
And where do you live, Mr. Harrington, right now?
15832 Highway 8 West, Grenada, Mississippi.
Is that in close proximity to any of your children? Do you live close to any of your children that live in Grenada?
Yes.
Which of those, who are those children? Who do you live close to?
Reginald, my youngest son, and my daughter Natalie.
What road do they live on?
Lincoln Road.
Lincoln Road. They live in houses next door to each other?
They do.
And if you were to leave your house and go to their house, go to Grenada, if you were going to Grenada, would you have to pass their house?
I left my house
Going to Grenada, would you pass Lincoln, the road that they live on?
Yeah.
Okay. All right. So you're closer to town than they are. Is that right?
I am.
Okay. Are you familiar with a place called Abundant Life Church? You familiar with that place?
Very familiar with it. I'm the pastor.
You're the pastor. How long have you been pastoring there?
42 years.
And you know where Sheldon and Tina Herrington live? You know their address? Is it on Broad Meadow?
Yes, it's Broadway.
I'll hand you what's been marked for identification. It's D-108. You recognize this? If you would tell the jury what that report should be.
Okay. 121 Broadway Meadows Drive.
Does that appear to be the map for that location? Subdivision?
It is.
It fairly and accurately depicts, it's a Google map, fairly and accurately depicts the area in which they live. Just answer, is that the area in which they live?
That is there.
I move for introduction.
All right, you did.
Mr. Herrington, do you go by, are you pastor, bishop, or preacher? What do they call you in town?
I answered all of them.
Actually, all of them. What do people normally reference?
Bishop.
Bishop?
Yes.
Now tell me, if you would, are you pretty close to all your children and grandchildren there in Grenada?
Very close. Very close.
Close to 10.
Very close.
And did he at any point in time in his young life begin working for you in any capacity or doing anything for you there in Grenada?
He's worked for me ever since he's been big enough to do anything.
And did you tell the court and the jury the responsibilities from the early age on up until July 8th, 2022, what Timmy would do for you and members of the family?
Yes. I do a lot of rental property, and one of the main things Timmy would do, well, he would work with us in repairing rental properties, but mainly cleaning up around them, picking up material, trash and whatever. But that was his main job, to pick up behind those that did the work.
Did you do other things on the rental houses? Like in the summertime, did he have other responsibilities as well as cleaning up, keeping the property clean and good repair?
Yeah, he would have assignments to do pretty much whatever came up. From time to time, I would have him working with contractors, maybe putting on a roof, or tearing out sewer, or picking up scrap metal and other debris, and just whatever came up.
Did you tell the court and the jury generally the locations of the property? I know you have a lot of units, but locations of the property. Did you own property in Elliott, Mississippi during July of 2022?
Yes, I own one property in the Elliott at 212 Mississippi Avenue.
And did you own any property north of town?
Yes.
Remember how much property you owned north of town?
Yes, at one time I owned two properties out of Tardale Road, which is north of town. And I had another property south of town, south of Elliott in Duck Hill. All the other properties basically are in Grenada city limits.
Did Timmy have any responsibilities in addition to the rental properties at the church throughout the years? Did he do things at the church similar to the rental properties? Cleaning up things of that nature? How active was Timmy in the church as far as activities within the church family?
Well, Timmy was very active in the church. In fact, he was the lead guitar player. He played for the choirs, and he even played for the services. So he was there every week, sometime twice a week.
Now, you've identified the map as being the area of DO8, being in the area subdivision out there at Glenmont, correct?
Right.
Now, if Timmy were to go to any of your property that was located south of Glenbrook, that he would have, the property in Elliott would be south of Glenbrook, correct?
That's correct.
Full window. Bishop, the location there where Tina and Sheldon live, did Timmy also live there during the time frame of July the 8th, 2022, come and go, to your knowledge?
He did.
Sustain the objection.
Are you familiar with the fact that Timmy came back and forth from Oxford to Grenada?
All the time.
Were there occasions where you saw him? Did you ever see him in the box truck during that time frame?
I did.
Just actually didn't see him.
That's not on that one.
You recall the time when Timmy got arrested in July of 2022, correct? And were you, at that time, was Timmy carrying on the same responsibilities as far as prior to his arrest that you described as far as rental houses and the church and responsibilities at that time? Was he doing the same things since he'd been doing time before that?
He was.
Did you at any time, was it a situation where you talked to Timmy on a regular basis about what he needed to do?
I did.
And did you have to give him details of stuff, or he basically do it on his own?
Most I would give him assignments to do. Sometimes I would give him 2 or 3 at a time, and he would do them on his time.
Told him what needed to be done, he did it on his time. That's all I have now.
Cross-examination.
So, if I understand correctly, if you needed anything done on your rental properties, you would let Tim know. If you needed anything done at the rental properties, you would let Tim know. You would communicate as your testimony with him. Is that correct?
You said when I didn't have anything done.
I'm sorry?
You said when I have anything done.
If you needed anything done at the rental properties, your testimony was that you would communicate with him what needed to be done. Correct?
You said when I have anything done. I had a lot of things to be done. Many times I had contractors to do the work.
Yeah. You've got 50 rental properties.
Yes.
And sometimes the commode will go out, or sometimes you would need debris cleaned up if a renter moves out, things of that nature.
Timmy didn't do things like that. He's not a contractor.
Okay, he's on contract.
He's not a contractor.
He's not your... What do you mean by that?
He didn't do repair work by himself.
Oh, okay.
He's not a contractor. I said he would do picking up material, he would clean up. Sometimes he might work alongside a contractor.
Did you just tell the jury that if anything needed to be done by Timmy on the rental property, that you would communicate with him and let him know? I'm not trying to trick you. I'm just trying to remind you of what you told the jury. Is that correct?
That's correct. That's correct.
Okay. Now, during July of 2022, Timmy was living in Oxford, right?
Yes.
Okay. Did you have Timmy's telephone number?
Always had his telephone number.
Okay. And if he wasn't in Grenada, would it be your method of communicating to him what was needed to be done to use that number?
I didn't usually call him on a number and give him assignments. Usually when he was in Grenada, I would tell him the different things that I'd like to see him get done.
Now, July 22nd, 2022, Oxford Police Department takes Tim Herrington into custody. Do you remember that?
Yes.
Okay. Do you remember investigators approaching you for any information that may be relevant to that time period or relevant to the disappearance and death of Jay Lee?
Yes, I remember.
Do you remember not giving them any information whatsoever?
I do.
Okay. Do you remember being called, subpoenaed as a witness to the grand jury proceedings? Isn't it true that when you were called to provide testimony about the time period of July 8th to July 22nd involving the disappearance and death of Jay Lee, that you took the 5th? You took the 5th. You said, I'm not going to provide any information to that body. Is that correct?
I don't have any information to provide.
You didn't have any information, right? Because you don't have any personal knowledge of what Tim Herrington was doing on July 8th, 2022.
No.
And you don't have any personal information or personal knowledge about whether Tim Herrington provided truthful information to law enforcement on July 22nd, 2022.
Yeah.
What's the goal? Now, I represent to you that Quentin Jeremiah, Quentin Jeremiah Love represented that his relationship with Tim Herrington.
I'm gonna let her hear the question first anyway.
That he testified that his relationship with Tim Herrington was close, like brothers. Do you know that to be true?
Sure.
Okay. Now he has described that he has seen Tim Herrington with girlfriends.
I knew that.
He has testified that he has seen Tim Herrington with girlfriends in the past.
Say that again.
Mr. Love has testified to this jury that he has seen Tim Herrington with girlfriends in the past.
Girlfriends.
Girlfriends.
I still don't hear that word. I don't hear the best.
What do you not understand?
I said I don't hear the best. I don't understand.
Oh, okay.
I don't understand what you're saying.
Have you ever known Tim Herrington to have girlfriends?
Yeah, what?
Have you ever known your grandson to have girlfriends?
I've seen him talk to girls, yes.
Okay. Have you ever known him to be interested in men?
No.
Okay. That's all I have.
Where you at? Oh, yeah.
Bishop, did Tim act independently of y'all's conversations, keeping up with the affairs that you told him to do over the years? Did he have to have instructions?
Hang on a second, hang on a second,
He opened it up.
hang on a second. What's the objection?
Did
Rephrase your question.
Did Tim act independently of you and his responsibilities that you gave him?
Ask him how he acted rather than.
How did he carry out his responsibilities? Did he need direction from you?
Ask and answer, Your Honor. Covered on direct and cross.
I'm gonna let him ask it.
Yes, he did carry out his, my instructions in the gun. I would give him several instructions, and he would do it on his time.
Whenever he got time to do it? Was it necessary for you to call him on a regular basis for him to carry out those responsibilities? Now, Bishop, did you really ever have any conversations with Timmy about his sexuality at all?
No.
Thank you.
May his witness be finally excused.
You can be.
Mr. Herrington, you're free to go. You're welcome to stay in the courtroom, whichever one you'd like to do, okay?
Suspended rest.
All right. Ladies and gentlemen of the jury, let me ask this. State gonna have any rebuttal? I'll give you a minute to think about it. I want y'all, I got some more business I gotta do. Don't go far, and I'll get some more class. Go to the jury room this time. Don't form or express any opinions. Don't talk about the case. Is that door closed? All right, it is now. Mr. Herrington, I'm going to direct these comments to you again. If you'll recall at the break not long ago, I advised you that you had the right to testify in this case if you wanted to. If you do choose to testify, you'll be subject to cross-examination. If you choose not to testify, the jury will be instructed the fact that you chose not to testify could not be used as any evidence of that you were guilty of any crime. I asked you at that time to be consulting with your attorneys and for you to make a decision. It would be your personal decision. It would not be your attorney's decisions, but your decision about whether you wish to testify or not testify. Have you had an opportunity to consult with your attorneys about that issue? Yes, sir. Have you reached a decision about the decision whether you wish to testify in this case or wish not to testify? What is that decision? Okay, and you've consulted with your attorneys in that regard? Correct. That your understanding, Mr. Horan, as well?
That's correct.
All right, all right. And at this time, the defense is rested, is that correct?
That's correct.
I'll ask the state, does the state have any rebuttal witnesses?
No, Your Honor.
All right, so we've heard all the testimony. All right, if you wish to renew your motion at this time, you may do so.
Your Honor, in the position that move again for directed verdict or in the form of a peremptory instruction to instruct the jury to find the defendant not guilty.
All right. I don't think there's been any significant change in the testimony from the time the state rested and the time the defense rested. For the reasons stated in the record, at the conclusion of the case states in chief, the court is going to overrule your motion for directed verdict. How long is it going to, who all has filed jury instructions or intended to file jury instructions?
We do, Your Honor. We're working on a couple. I'd like to have a.
I'm open to suggestions.
Before we waste a lot of time.
I'm open to suggestions on how to handle this jury. Do you think we're going to get these jury instructions together, what time it is, and get this case to the jury at a reasonable time, or not?
I do not.
Your Honor, I have filed instructions. I have not received their instructions, but I do have to submit additional instructions. So I don't think that we will get it to them.
Well, let me ask you this. If we started right now, what time do you think we could have jury instructions together?
2 hours, probably.
2 hours? You think we could have it ready to go to the jury? If we worked under the assumption we could have this matter ready to go to the jury at 5 o'clock, I'm not saying, I'm just saying if we could work under that assumptions with the parties, the jury's not going home this afternoon anyway. They're either going to be sitting in the jury room or sitting at the hotel or deliberating. Do you think we could put it to the jury this afternoon or not?
I don't think so.
I believe it's been a week and a half. I don't know about Mr. Horan, but we would probably both like the time to prepare to do the presentation for closing arguments in the morning and finish the jury instructions today, if that's possible.
I agree with that, Judge.
All right, I'm gonna send the jury. You've rested in front of the jury. I'll let the state finally rest in front of the jury. I'll send the jury back and have them back at 8:30 in the morning, being prepared to move forward with closing, reading the jury instructions and closing. Art, y'all got anything else I need? Anything I'm missing? All right, all right. We ain't leaving until we get jury instructions, whenever that is.
I agree with that, Your Honor.
All right, all right. Show the jury back in. Okay, it may be, we got one missing. Now we got two missing, but it's gonna be good. So quick as Dana gets back, we'll bring them back in, okay? All right, the defense having rested, the state having wish to call any rebuttal witnesses?
No, Your Honor, at this time the state addressed.
All right, state has rested. That means you've heard all the testimony that you're going to hear in this case. I've got to sit and watch everybody else work. Now I got to do is start doing some work. I got to figure out what the law I want to instruct you is. And when you hear that law, you're going to have to figure out then you can come up with it. That's going to take a while. I've got to listen to these guys argue about what they think the law should be and what instructions I should be giving y'all is what the law is. That's not going to happen in time today for y'all to make this decision. I want to excuse you for the evening. You'll be back at 8:30 in the morning, and as soon as we get back, you should start hearing closing arguments. I'll read the jury instruction to you. Y'all have a prepared closing argument, and then y'all will finally begin your deliberations. But not yet. Remember the court's instructions. Don't discuss the case even amongst themselves. Don't express or form any opinions until you've heard the law and the arguments of counsel and begin your deliberations. Don't investigate the case. Stay away from any news reports of this matter, okay? And we'll see you back at 8:30 in the morning, okay? All right. I think we've given you, or Brooke has probably delivered y'all court standard instructions. They're the same ones that's been used in this district forever. I'll make sure y'all get copies of that. If y'all would, if you haven't filed your instructions, let's go ahead and get them filed now. And we'll start. Do you wish to have an on the record the conversation first, or have it in chambers preliminary discussion of the jury instructions before we get back on the record?
No, I have a jury instruction that I've never presented to this court before, and I like to have discussions with the court about it before we waste a bunch of time, maybe get some stuff off the
I'm gonna have to hear them all. I'll start whenever y'all think y'all are ready to start.
I just wanted to get, we could have in conference.
Let's have a free conference, discussion on jury instructions. Anyone that wants to, y'all are welcome to stay, but it's finna get real boring real fast. I'm gonna be honest with you as far as what's been to take place in this courtroom anyway. But let's have a pre-conference instruction.
I just want to say, we haven't received any.
No, I was hoping we could.
From the defendant.
Let's talk and then we'll go from there. See what each side number, Kyle